Welcome to Looking at Legal Stuff. Today we have 14 hearings in the case of a couple who are divorcing after 24 years of marriage and with 5 children, ages 2 to 14. Mom says she's always been the primary parent and a stay-at-home mom, while Dad has been the primary breadwinner. She says this has led to financial abuse, where Dad controlled every penny that came into the house and only gave her an allowance of $130 a week to run the home. She also claims that Dad has had outbursts of anger with her and the children and has made attempts to manipulate and harass them. So much so that their eldest child doesn't want to see his father. Mom would like the court to order supervised visitation, especially for the older two who've had to witness more of these incidents with their father. Mom is also asking for a family support payment and exclusive use of the marital residence, and she'd like a GAL appointed to investigate before giving Dad any unsupervised visitation. What do Dad and his lawyer have to say about her claims? Let's find out.
Ellis and Ellis.
Good afternoon, Your Honor. Tanya Green for Mrs. Ellis.
Good afternoon, Ms. Green. Good afternoon, Mr. Davis. Thanks for your patience.
Good afternoon. Excuse me. Good afternoon, Your Honor.
Okay, hold on. Let me just adjust something here on my screen and then okay. All right, so this is 23-3-000-8308 on for initial hearing. Let me just, I know that I have some proposed orders from the parties here. I just want to make sure I have everything in front of me. So I have, and I'm assuming, which is never a good thing to do, but most of these proposed orders were submitted when the parties were representing themselves. And so I just want to confirm that the council is comfortable working off of those proposed orders, or are we in a situation where you're wanting to potentially draft orders after a decision's made today?
I believe we'll need to draft orders. Our motion is a little bit different than my client's original motion. And so I think there's things that are not addressed in her previous proposed orders that are requested now.
Okay, so I will set Miss Ellis's proposed orders aside. Mr. Davis, do you feel the same way, or are you relying on the proposed orders that Mr. Ellis filed previously?
The only proposed order we'd probably rely upon, Your Honor, is the proposed parenting plan that we referenced. Now,
Okay.
you may still wish us to draft it from scratch or whatnot, but
All right, I will set everything but the parenting plan aside from those as well, just so I don't get confused, because I have a giant stack of stuff. You'd think I'd have less of a stack at this point in the docket, but unfortunately, that isn't the case. Okay, thank you for your patience. And I have reviewed everything that has been filed in this case. I do have a preliminary question, and I'm happy to wait until the parties begin. But there was, I'll wait. I'll try not to forget. There was a couple references in some of the documents to two things that I didn't see elsewhere. And so I thought maybe I was missing something, but hopefully that'll be resolved with hearing from counsel. So Ms. Green, I'll turn it over to you.
Thank you, Your Honor. So initially, both parties represented themselves and had filed initial temporary orders. Mrs. Ellis filed, set a hearing. Mr. Ellis responded, filed his own motion, and set it to be heard with less than 3 weeks notice. So when Ms. Ellis hired me, I thought it would be easier to reassign it to the attorney docket and hear a new motion. So I'm not relying on any of the pleadings that Ms. Ellis previously provided prior to counsel. So I did not submit those as bench copies for review either. So I'm relying on the materials that have been presented only since my appearance in this matter, and that's what I'm relying on for our arguments today. So my client has been the primary homemaker, stay-at-home mother for the children. This is a 24-year marriage. My client married Mr. Ellis right out of high school. They've had 5 children together, ranging in age between 2 and 14 years old. And Mr. Ellis has been the primary breadwinner and provider for the home. My client is asking to have exclusive use of the residence, to have a restraining order to prevent him from coming to the home, harassing, intimidating, or causing any harm to her and the children, as well as a parenting plan that provides supervised visitation, given some of the abusive and both emotionally and physically actions against the children and my client. My client has provided a pretty historic account of only a portion of the things that she's encountered with him, with the children and herself, and during their marriage. Some of the important ones that I think matter is an ongoing financial control and financial abuse. My client accounts repeatedly of her husband's controlling all bank accounts, controlling her access to funds, giving her an allowance of $130 per week for expenses, for food for the children, $130 per month for clothing and other necessities for the children, and basically managing every penny that she was allowed to use throughout the marriage, including taking over her own separate bank account she had when she was younger, and controlling every bit of money that she brought into the home when she did work prior to the children's birth. Mr. Ellis brings up the ability of my client to work. That historically has not happened. You can look at the tax returns provided showing that the preschool that he purports that she can make money at earned under, I think it was $700 net income last year, or I'm sorry, he provided 2020, 2021 tax returns. And so 2021 didn't have any income, 2020 had a $700 net income from that preschool. And an additional job that my client had was a sewing job that she made minimal, if anything. So my client has been reliant on Mr. Ellis to provide support for the household since their separation in October, and then again, a separation in December because of conflict over who would have exclusive use of the house. Mr. Ellis has basically established an amount that she is allowed to spend and taken all the rest of the joint funds and put them into a separate account. So my client has basically been fearful of even using the joint account because if you look at Mr. Ellis's accounting of the financials, he states how much he's provided to my client and how much she's indirectly earned from using the bank accounts or using expenses to pay for her household expenses. He's basically halved all the expenses and given her what he purports as half his check, but is not sufficient to meet her needs or the children's needs at this time. He has been out of the household for several months now. I believe it's been 4, and has a room that he is staying at. We don't have any information on the costs because he fails to provide anything in his financial declaration of what his actual expenses are. Instead, he's asking for a monthly budget equal to what my client needs to maintain the household for her and the children to reside with all their expenses. So given that brief history, and I'm sorry, I don't really want to go into the more severe physical altercations. If you've reviewed everything, I don't really want anybody to have to relive those experiences, but it is a pretty substantial history of abuse of the children and my client. And so it is important for the court to realize that a restraining order is more than appropriate to prevent any more anger outbursts and any more attempts to intimidate and harass and abuse the children and my client. So given that, my client has requested a parenting plan that provides supervised visitation for father. We're not asking for a professional supervisor, but we do think it's important for the visitation to be supervised by an agreed third party. It could be a church member or somebody else. Just given that the contact in the last few months especially has been very direct and it seems manipulative with the children. telling them or trying to encourage them to pick dates and times that they'll see dad, and other information gathering from my client's household that is concerning. And so given that my client did not want to restrict time completely for fathers had a pretty open schedule to have visitation, but it's very contrary to what he's requesting. He's very inconsistent with his schedules. He's very inconsistent with when and if and who he will take with him for his visitations. And so that's why we're asking for a set schedule of Wednesdays and Fridays for the 2 hours and Sundays every other week after church for him to spend time, which provides a regular schedule and provides him the ability to have all the children, not just one per night over the weeks, which is very disruptive to the children's school schedule and very difficult for him to have one-on-one time with 1 or 2 children at a time and leave the rest at home. That's not the way parenting should happen. I know that he has limitations at his home, but he has had very rare overnight visits and mostly just the younger 2 at this point. So, excuse me. My client is asking that he also complete anger management and DB assessments, allowing collateral contact for my client to recount any history or anything relevant, and to complete any recommendations. The decision-making should also be limited to my client, given the history of abusive conduct, domestic violence, child abuse, and abusive use of conflict, basically involving the children in conflict in decision-making regarding visitation and things related to finances, including telling children that mom's in charge of their weekly allowances now, once he has provided her minimal amounts to support herself and the children in the last few months. We're asking transportation be provided at each parent's home, the parent to remain in their car during pickups, and no communication during the exchanges. So even though we are asking for a restraining order, we are allowing continuing visitation, or the visitation transportation can be arranged by the third party, which is normally done, but at this point we don't have any agreements, or we haven't had any discussion about that supervision provision if the court's going to provide it. For financial matters, my client is asking for spousal support. This is a long-term marriage, not over 30 years, but 24 years is very long. And having that my client has not had any gainful employment for a decade, with being the homemaker and caregiver for the children at husband's request, and the minimal work that has been done has been nominal at best. The requirement that my client work in home provides almost no ability to provide any substantial income, and especially with 2 young children under the age of 5, it would be nearly impossible to find any employment that would more than compensate for the cost of daycare if she were to find employment outside of the home. So we did impute my client at 0 because she hasn't had any substantial income or employment for child support purposes. My clients asked for $5,000 for spousal support because Mr. Ellis states in his pleadings he's provided at least $4,600 per month plus extras from joint accounts, etc. So in his statement, he's acknowledged that he's providing at least $4,600 per month to my client. So $5,000 is appropriate given the expenses and needs for the household. You can look also at the financial declarations of both parties. My client has budgeted $6,200 in her financial declaration for her and the children's household expenses. Mr. provided his financial declaration showing a household budget of $5,000. So the $5,000 is not unreasonable for the household expenses and costs. And Mr. Ellis has provided his financial declaration based on having the children half of the time, and what he presumes the expenses would be, because it's not his actual expenses. Court can also look at all the sealed financial documents provided, showing a clear accounting of funds that are available. It also, in addition to the financial source documents my client provided, show the transfer and multiple accounts that Mr. Ellis has control over, I'm not concerned about the retirement accounts and so forth, but it does show several bank accounts with money available in them that are in his control, including the bank account he removed the $27,000 from the joint bank account into. My client is asking for half of that to be awarded to her. Those were joint funds that need to be separated so that she has access and use of those funds as well. Let's see, and then for child support, depending on what the court determines as far as imputing my client to an income or not, given her history of non-employment, if the court orders a $5,000 spousal support award, his child support award would be $876 and would still leave him with about $1,500 per month. Given that he's in a home, we don't know what his expenses are for living there, if he's paying any rent, utilities, or anything. That will more than supply for the needs of the household for my client to pay all the household utilities, the mortgage, and all the other expenses that are necessary for her to remain in the household. Otherwise, if we had provided the option of he will pay all those household bills and expenses, we can reduce that amount, but the concern is that there may not be payments made if given the choice of providing payment. So we are asking for the spousal support so my client can control that those mortgage and utilities are paid and not shut off. Mr. Ellis also provides a child support calculation, and in his declaration, they're attached. He provides that in a normal situation where my client has zero income, which he acknowledges, and based on his income, his child support obligation would be at least $24.50 per month. And with my client imputed at minimum wage, he would be paying at least $2,183 per month. So given those expenses, the court can either award spousal support and child support or a family support amount that more than covers her expenses and necessities for the household without having Mr. Ellis control and limit her access to those finances. My client is asking for exclusive use of the property. There has been some accounts in her declarations and more recently just unwanted contact at the household. Mr. Ellis has requested in his materials to be allowed to have continued access to the outbuilding, but that hasn't been what has happened historically. And even as recent as this weekend, which is not in the pleadings, there's been unwanted contact at the household that needs to stop. Honestly, there's no need for him to be there unnecessarily without reason or cause, unless it's a time for visit and pick up the children. And that's why we're asking for the exclusive use, that he stay away, and the restraining order. My client also wants to make sure that she has access to any of the household items. I think in her last declaration we provided, Mr. had either inadvertently or intentionally shut off the internet in the household. And it's incidents like that that my client is concerned about ongoing contact and access to the household. Most recently, I think there was a tractor that keys were required. So my client does want to make sure she has access to anything to use the property on the household that's needed. Property, I think there's no dispute. My client can keep the Dodge Caravan and property in her possession. Mr. Ellis only disputes her having control of the property in the outbuilding. As long as it's kept, undisturbed, there's no reason for him to need to be there and have access to that. And neither party should transfer any property or remove any property from the household. Let's see, as far as debt, I don't think that was addressed by either party. The household expenses, the court will either order spousal support or have Mr. pay those expenses. All the other standard language, not changing insurance, each pay their own expenses, should be approved by the court. My client is asking for $8,000 in attorney's fees. It's actually cost her more than that to come to court at this point. And the court, we're also asking for a GAL to be appointed because of the concerns of contact with the children and the concerns of the abusive behavior, it would be important to have an investigation done. My client obviously doesn't have the funds to pay for that, but is asking that one be appointed either at court expense or at Mr. Ellis's expense, since he was the primary wage earner. And I believe that covers everything, Your Honor.
All right, thank you. Mr. Davis, whenever you're ready.
Thank you, Your Honor. Excuse me. As you read, obviously, we respectfully disagree with many of the allegations and other issues. As background for the court, this is a case that we a little different than many we see, at least on these dockets. The parties voluntarily separated. The parties voluntarily moved into separate living environments, or kind of involved. John has continued to support the family voluntarily this whole time. The separation of the parties seemed to agree with that was October of 2022, when he moved into the shop building that has an office in it on the property. He eventually moved off the property. My understanding is the end of December. So the parties have essentially been separated 6 months, or well, I guess at this point, almost more than that. 7 months now at this point. Again, he's continued to support the entire family. The family has traditionally lived a very frugal life that allowed them to make it on one income. You know, they are both devoted church people, and that was important to them that they do what they can, if possible, to live frugally and put money in savings and whatnot. Thankfully, they were able to do that. Mrs. did work out of the home occasionally. We don't dispute that John was the primary wage earner, but we do dispute that she doesn't have the ability to work moving forward. John, as we explained in this situation, is continuing to pay all these expenses and bills because he was hoping to reconcile. They worked with preachers trying to work through that. And, you know, some part of him, I guess, is still hopeful that will be the case someday. But for now, we're in this situation where we need to deal with these issues. Thankfully, the savings that the parties were able to, accumulate over the years allowed Mrs. to spend $20,000 in attorney's fees to 2 different firms. She first hired a first attorney based on the bank statements in December of 2022. We don't know exactly what happened to that money or why that attorney didn't file anything, or exactly the details on that. It appears she then spent another $8,000 of the joint account for Miss Green's firm, and has since spent some additional money, approximately $3,000 more from the joint account. So we have about $20,000 in attorney's fees she's removed since December from the joint accounts. That's apart and separate from the money that John's been paying her every month, as well as paying the house payment. From what was left in these savings, he's paid my firm $8,000 to match what Miss Green's firm was paid. He's paid the taxes for the entire year, as well as insurance, because those charges are separate from the mortgage statement. It's a situation where the family has always lived this frugal life, and Mrs. now is attempting to try and sell the court on a much higher standard of living and these much higher expenses than the family lived on when they were together. It is a situation where John makes good money, but it's not exhaustive. As we explained to you, he makes around $8,600 gross. The nets, if you count potential taxes and whatnot, is quite a bit off of that. The family historically hasn't paid much tax because they have 5 children and they're married, but that's going to change now. They're going to be living in separate households regarding various deductions and whatnot. John doesn't contest that he should have to pay some sort of spousal support to his wife and continue to do that for some period. But he believes it should be fair and equitable, fair and reasonable, based on true need and the ability to pay. Excuse me. Using possible tax figures from the child support worksheet programs, we estimated John's net around $6,500 to $6,600 net. That's the money that's available for the family, right? For everyone, including John and whatnot. And so we believe Mrs. should be imputed at 30 or 35 hours per week, a minimum wage. Obviously, she has young children, and that is an issue. But it can't be a situation where she's already been separated for 7 months. And we don't know what, if any, action she's taken to try and at least supplement income, whether that's full-time or whatnot, but it can't last that way forever. And we would believe the court should impute to her whether she's actually has a job or not. Regarding her need, it is a bit of a variable situation. Her original declaration on when she was pro se was, she said she needed $54.30 per month was her expenses. The one she submitted to council, the second one, she said she needed $62.08 for monthly expenses to meet her needs. Quick look of that. I won't pick this apart forever, but the first one, the $467 on her financial declaration for taxes, insurance, that's already been paid through the entire year and probably into early next year. So that isn't a need that she's going to have, at least in the short term. She lists a total of $500 for things like vacation and home repair and vehicle maintenance. Yet she also lists a gas and vehicle maintenance at $350 under that section. Yet she's not working. Obviously, she has to take the kids places and whatnot, but there's some question of whether that's a double dip or not. If you just subtract those big obvious ones, the child expenses. Now, obviously, she has child expenses. Those are real expenses. I think traditionally the court has kind of balanced that with, yes, but child support, so it's to pay for those diapers and children's clothes as well, to give her money on the maintenance side, and the child support side is a bit of a dipping situation. If you just add those three big numbers, 467, 500, and the 590, that's 1557. So her need, based on her most recent declaration with the increased numbers, is 4651. That's not picking apart anything else in the situation. So while we have a long-term marriage, and my client has been the primary, bread earner or wage earner rather, maybe, traditionally the courts on a long-term marriage kind of tend to equalize the income or something to that effect. We can't give one party the lion's share of it and starve the other one out. Here, equalized, if he nets someone around 65, 6,600, that's about 3,300 to Mrs. Ellis. And then you figure out child support from there, for example. That may be one approach that the court tries to do. But to ask for 5,000, which is not even close to equalization, plus child support, essentially eliminates all available money. That is based on their most recent child support situation. That leaves John with I believe less than $1,000. John has been kind of living with a friend from church. He's been paying him $300 and some a month or so to rent this room, all with the idea that he's going to continue to work with the church leaders and work on marriage counseling and whatnot. Obviously, that has not been successful thus far. He needs to be able to get his own place. He needs to be able to have the children overnight. He needs to be able to meet his own expenses. There's just not enough money to go around if you follow Mrs. Ellis's requests. Mrs. Ellis describes how she's afraid to use the joint accounts, yet the financials we provided shows her that not only is she receiving the money every month, every week, $500 and some every week from John, but she continually uses those joint accounts for all kinds of things, Targets, coffee, whatever, restaurants, McDonald's, whatever. So I don't see why she's afraid to use those accounts or where she states she's fearful. But those accounts, unfortunately, have been exhausted. Between the monies John's been paying her and she's been using from the joint accounts, including the $20,000 she made her attorney's fees, she's received more money than he's made during that same time period. Thankfully, for the savings, they've stayed afloat. John reports that if I wrote it down correctly here, there's about $10,000 left in one account. The joint account he thought was more, but she took $2,000 last week for attorney's fees, so it was about $3,000 or so in that account. That's it. The savings have been exhausted, we believe largely by Mrs. Ellis. Through agreement of the parties, they work together. They've been trying to do this. Similarly, this is, Mrs. is asking for a TRO in this case. that's going to directly affect John's job. He is a computer, I forget the exact word, IT professional, let's use that. He has security clearances through various school districts and governmental agencies. He quickly gave me a couple of examples like North Clackamas School District, Beaverton School District, Hillsborough School District. A domestic violence restraining order, which is what's being requested, is going to directly affect that and other security clearances he doesn't even know the extent of that his employer just submits him for. And so that's gonna essentially restrict his employment significantly, and there's gonna be far less money available. If there's concerns about John coming to the house, although he denies there's been any issues or incidences this entire 7 months of separation, the court can easily say, Mrs. Ellis is awarded the house. It doesn't have to enter a restraining order, domestic violence restraining order. He would like access to the shop by agreement of the parties. He lived there for 7 months at the beginning of the 7 months. But to award her the house would alleviate that problem. It's a similar situation with the parenting plan, where actions speak louder than words. For the 7 months or 6 months before she filed her motion, in her own material, she never asked for a TRO. She didn't ask for supervised visits. In her motion when she was pro se, I understand that has now been requested through counsel, but as I mentioned earlier, she hired counsel for $9,000, previous counsel, in December, and so it's not a situation where she didn't have the money to protect herself or to do whatever she thought was necessary regarding restraining orders or supervised visits or whatnot. It's just now that after 6 months that she decides to ask for that. They've continued to exchange the children. John's been pretty hampered by this one room situation that he's living in with this elderly person from church. He has the kids quite frequently, all the kids except his oldest son. There's some disenchantment there between them and the breakup of the parents and whatnot, but they're working on that. And he believes the son has indicated to both of them that wants to try and do some visits and whatnot. But he's had Carly and Rosabella, and especially the two youngest kids have always been there. Routinely, the two youngest kids are there typically multiple times a week. John and Mrs. Ellis have continually, communicated through text and whatnot. He provided me, of course, late today after we received our latest declaration, countless texts that show that communication if necessary, if the court wanted to see that. So they've been getting on. They've been doing this just fine. There's no reason for a TRO or supervised visits of that nature. The allegations she talks about are significantly old at best. Talks about when the children was 10. Well, the one is 15, I believe now. So that was 5 years old. John did explain to you and denied those situations, or they weren't exactly like Heidi wants to try and portray them. She mentions the chair or whatnot. That was the beginning of their marriage. And he disputes exactly how that went. But the end result is none of these have occurred for several years. The parties engaged in unsupervised visits and whatnot the last 6 months. There's no reason for those significant restrictions. Mrs. Allison, when she was pro se, her proposed parenting plan that the court, I'm sure, has in front of it still, proposed unsupervised visits every Wednesday and Friday from 6 to 8, and every, I believe, it was every other Sunday for a good portion of the day. None of that was supervised or whatnot, and so it's just now that she's asking for that. But there's been no incidences of separation that she identifies specifically that I saw, anyways. That would justify anything less than that. John is like I said, hampered by the living environment and his ability to transport the kids when he has just the work vehicle with 5 seats in it. So he's tried to spread out the visits rather than having them all go in at one time. We understand that his proposed parenting plan isn't a traditional one where the court typically would, have the 5 kids go at once and whatnot. But for the reasons of the living environment and the transportation right this second, we're somewhat hampered. His proposed plan spreads them out a bit. The kids seem to prefer that and request that spread out versus all of them together at once. And so his proposed parenting plan lays that out for every child. Basically, it's a midweek visits as well as one full weekend, a 3-day weekend every month with each child. That was his proposed parenting plan when he was in pro se, and he asked to continue that. But that's the basis of that. I understand it's not typical, but the situation is what it is. So he's hopeful that the court won't give Mrs. Ellis his entire paycheck, and he has some money where he can actually rent his own place where he can have overnights with these older children. You can't have teenage boys and girls sleeping in the same bedroom and whatnot conveniently. You have to spread them out in this friend's house if that was going to try and be the case. He's hopeful to get his own place where he can have them overnight and believes they want to be there. Excuse me. Regarding the finances, lastly, Your Honor, and I'll conclude. I know you read most of this. Regarding attorney's fees, we don't believe there's any reason or basis for that. Presumably the court's going to award Mrs. Ellis some sort of maintenance. We hope that it's far less than that they've proposed, obviously, but through the parties' limited savings, she's already hired 2 different attorneys at the cost of $20,000 from the joint accounts. That's in addition to the money he was paying her. Like I stated, there's no big pot of gold left anymore. At least as far as the joint accounts. Mrs. Ellis reports in her financial declaration, the first one, when she was pro se, I believe she said there was 17,000 in liquid funds, 22,000 liquid funds in her first financial declaration. In her second financial declaration with counsel, she says there's 17,500 in liquid funds. That's presumably after she hired counsel, because counsel was filing that for her. So if that assumption is correct, and I'm sure we'll hear otherwise, or the different, clarification on that. The 20,000 she's already spent on attorney's fees isn't part of that 17,500 she still has left. And so she in fact actually has more money than John does, because he's been giving her a good portion of the paycheck and whatnot, paying the full house payment, all the stuff we described to you. So we're asking the court to set reasonable maintenance and set a reasonable child support amount, and providing him enough money to survive and to get his own place, so that he can expand the parenting plan, have 5 children, hopefully all together, and have places to put them and whatnot. He did his financial declaration put what he believed was a 3-bedroom home in the Woodland area, what that might look like someday. And so that's our request today, Your Honors, to provide equal, I can't talk today, it's been a long day. Equalization of the income and whatnot, and a fair resolution regarding that, as well as continue to provide him unfettered access to the children and continued unsupervised visits and et cetera. So this internet issue, I missed one here. Internet issue, that was a situation where his employer's router was at the house. He disconnected it because he needed to return it. He's not living there any longer. It temporarily, because one wire wasn't hooked up. Mrs. contacted him within 10 minutes, is rehooked, because he told her exactly which wires to connect, and it was just an inadvertent situation. It certainly wasn't a intentional thing, and if it was fixed within 10 minutes when she called him. So that is the conclusion, Your Honor. We appreciate your time and appreciate the long docket that we've had here.
Quick question, Mr. Davis. Was there so approximately $20,000 withdrawn by is what the claim is, withdrawn by mom for attorneys, and then mom's complaint alleging 27,000 transferred from the joint account to an account of dad's. Do you agree that that's accurate?
Somewhat, Your Honor. Yes, the proof is, I don't think she denies she spent 9,000 McKinley, Irving, and then another 8,000 plus all the recent stuff, the 3,000 with Ms. Green's office. There was 27,000 removed from the account to pay family expenses, such as the 6,700, I believe it was, of the taxes and insurance for the family home. That's not including the payment that we're due. So that money's already been paid for that. From that money, also, Mr. Paid 8,000 to my firm as an initial fee deposit, somewhere to Ms. Green's firm. And so that's where we are. So I think he, as I mentioned earlier, there's something around 10,000 in that, and the joint account has something around 3,300 in it. That's the extent of the money left that he has control of. Mrs. 17,500 in her financial declaration. I don't know where that money is.
Okay, so of the 27,000 withdrawn by him, there should be about 14 left. Is that
13, yeah, something like that.
okay?
And he's here if I'm stating that wrong. He says I'm stating
Yeah.
it wrong.
I can help you with that if you'd like.
Okay, go ahead.
Yeah, of the 27, there's close to 10 left. There was also a $1,200 homeowner's insurance that was paid out of there. And the reason that I came up with the $27,000 amount is because at the time, Heidi had only spent the $9,000, not counting all the other charges. She'd only spent the $9,000 on attorney's fees. So I took 27 and moved it to another account, and I left 16, which is 27 minus 9, in the joint account, knowing that she was still accessing it. She also has her own individual account that she has money in.
Okay, thank you. The screen, do you have any response? Or anything
Hi.
you want to address?
Yes, Your Honor, just briefly. So I should have objected, but I do believe that there is a concern about the statement that Mr. Ellis just made about the money that was taken out of the account. The $27,000 that was taken out was, I don't think, comparable like he is stating for the 9,015 left, because the 15,000 was left in the account after the removal of the 27,000 was continued to be used by Mr. Ellis to pay my client's allotment of funds. There are several withdrawals on that account that were taken out that were not my clients. So I don't think that's an equitable division if that's what Mr. Ellis is trying to purport. Additionally, I would want to have proof of the other expenses. I have not seen anything in the records, and I apologize if I skipped it. There were over nearly 300 pages of financial records provided, but if they're disputing what my client provided at the beginning of my representation, is that there was a transfer of the funds to that separate account and no accounting for how those proceeds were left. So to our knowledge, the 27,000 was still in that separate account that Mr. Ellis has, unless he provides any new documentation. All the financials that were provided and re-provided to court today for this hearing are prior to my filing of my motion. They were filed when both parties were pro se. So we have no new information in the last month on the accounting that was just stated in court today and not in any of the pleadings. So I just want to clarify for the record that testimony is unconfirmed.
Okay.
The other two issues I would like to address is that there's a mention that my client wasn't afraid to use a joint account. She actually made a statement in her declaration that Mr. Ellis said that she was embezzling money when she used money from the daycare or the preschool business. And that's a pretty clear suggestion that if you take money out, there could be criminal implications. Making threats like that is pretty significant. So I am concerned that he's saying that there's a statement that she wasn't afraid to use the money. Additionally, it's not uncommon for survivors not to report their domestic violence and to minimize or try to produce something to avoid the amount of repercussions from acting in a way that their abuser would define as contrary to what they want. So my client stated that Mr. Ellis is always wanting the parties to be one-minded, which means his mind or no way. So given that they're comparing her pleadings that she filed when she was pro se versus when she had counsel, I don't think is a fair and accurate representation of what was appropriate or necessary. I think that the attorney filed pleadings are more representative of what's appropriate once there was some protection and not fear of reprisal, because she's going head on against her abuser in court. and having to address those in court in that fashion will minimize the things that you think are appropriate and safe, given the situation that that's how you're going to have to deal with it in court by yourself. So I just want to bring those to the court's attention and allow you to make the decision that you're going to based on the information provided.
All right, thank you. First and foremost, Ms. Wade, can we have the next 3 names for guardian ad litem?
Your Honor, can I be briefly heard on that last issue in 1 minute?
No, it's okay. I'm not going to go too far down that rabbit hole today because I don't think I have enough information.
Okay, the next 3 names on the list are Heather Kale, Amy Turnbull, and Ann Height.
Ms. Green?
I'm not familiar with Heather Kale, so I'd ask to strike her, please.
Right. Mr. Davis?
Your Honor, I don't believe I've worked with either of the other 2.
All right. Amy
So I
Turnbull.
would ask the court to appoint who they think is best for this particular issue.
All right. We'll go with the next on the list then, Ms. Turnbull. So I think a guardian ad litem is appropriate in this case, and I think we want one to get started as quickly as possible. So we'll get Ms. Turnbull on board. I would like, and I guess this is to whomever is going to be drafting these orders, an interim review sooner, maybe a little sooner than normal. And so 6 to 8 weeks out versus, 3 to 4 months out. On the parenting plan as of right now, I'm gonna reserve on the 191s. I understand a lot of the concerns that are being raised here. I also I'm gonna at this point, until I hear more from a guardian ad litem, I'm gonna adopt the mom's proposed parenting plan with Wednesday, Friday, 2 hours every Wednesday, 2 hours every Friday, and every Sunday. And Ms. Green, did you indicate how many hours on Sunday?
I believe the schedule had, I think it was every other Sunday, and I believe it's set from after church, approximately 4 hours, I think it was. Let me go back and check this.
Okay, that's what I had.
Sunday, actually 9 a.m. to 6 p.m. So they do attend church, and so the intention was after church, the children would go and then be with them after church until 6 p.m.
All right, so every other Sunday until 6 p.m. I don't know when. Hopefully the parties can work that out when church ends. I don't know if church is done after 9 a.m. I'm assuming. Okay. At this point, I'm not going to order any assessments or anger management. I'm going to reserve for the GAL. Same with decision making. I'm going to keep that joint at this point in time. Transportation from each other's homes, parties to stay in the vehicle, and then there would be a third party. So I am going to adopt that portion as of right now. So I understand Dad may see that as a little bit of a step back, but it'll be an opportunity to be with all the kids at once. This is a 24-year marriage. I'm not going to get too far in the weeds with the 27,000 removed and then the close to 20 removed from the other side. I don't know that that's necessarily indicative of somebody that's scared to utilize the money that is available to them. But I also understand that mom has been primary caretaker of the children for an extended period of time and can't immediately join the workforce, especially when we have 2 children under the age of 5 that don't even attend school at this point. And frankly, without knowing much of mom's background, whatever income she makes could be what daycare costs. And so I'm not gonna, again, I don't want to go too far in the weeds on that, but at this point, I think a family support amount is appropriate. So that will be kind of spousal support, child support combined into a family support amount. I have reviewed the numbers, the mortgage amount, and I would agree with Mr. Davis that some of those numbers overlap, and I don't want to say double dipping. That makes it sound like an intentional, act, but it's the way it's listed is probably frankly not phrased very well. Those forms have been the same for a long time. So I reviewed all that. I know the mortgage amount plus the general, I think the mortgage is $2,200 approximately. The property tax is claimed to have been paid for the year. So and looking at just kind of running through the rest of the numbers here, and then knowing where Mr. Ellis falls, essentially because I think the child support worksheet provided by Mr. Davis shows his $87.24 a month minus that $5,000. He's with $23.97 a month. If we take another 800 and I have the number here somewhere, 876 off of that, then he's that's pretty close to not having a living wage. Granted, there are some savings, but ideally, I think the parties probably don't want to have to live off of savings moving forward. So taking all those things into consideration, the amount of children that there are and the amount of the cost of everything at this point, I'm going to order a total family support in the amount of $5,200. As for any restraining order, I think other than the pickup and drop off at the home for the 2 weekly visitations and 3 every other week visitations, I'm just going to ask that Mr. Ellis not go on the property without permission. And I know that Mr. Davis indicated, and Ms. Green, you didn't respond to it, and he indicated it was late kind of discovery information to him as well, that the parties have been able to text back and forth. I don't know if you agree with that, or if you're at this point wanting, our family wizard or some other type of app to be utilized moving forward, given that I'm not putting in anything other than a temporary family law, or I'm not doing the restraining order.
So I'd have to ask my client if she has a preference for our family wizard. I know that they have been texting, but my client, I'm sure, is concerned about any abusive behavior and conduct, and our family wizard is good to kind of restrain that, especially tone and things like that. And then as far as like access to the property, I think my client would prefer, you're saying the third party is going to be there, so there's a third party supervising, correct? Is that my understanding?
Yes. So yeah,
Okay.
I'm adopting basically mom's proposal for visitation at this point.
Okay.
Did you say supervised visitation?
Yes, but not professionally supervised. And that's just until we get our interim GAL report and I get some more information.
My preference would be our family wizard, just to prevent any conflict and so forth. And it's all documented, so if there are any concerns, it's easier to access.
All right. So, and in lieu of a restraining order, which I am not granting, I will order the parties to begin communicating via our family wizard. My hope would be visitations, tomorrow's Wednesday, that we'd get a visitation starting tomorrow. Miss Wade, did you need something?
No.
Okay, I just saw you unmute and I didn't know if you were trying to get my attention. So I would hope that those visitations could start tomorrow. I understand that there may not, it may be a tough scramble to get an agreed supervisor between today and tomorrow. So as soon as there's an agreed supervisor, but there shouldn't be, I would hope that no party unduly delay these visitations because of this supervisor issue. If let's see, I'm not imposing any attorney's fees at this point in time. I'm going to reserve on that. Sounds like more of a sticky wicket than any of us may understand at this point. Clearly, both parties accessed funds to pay for attorneys from the joint accounts. Great. We're going to leave it there for now, and we can delve into that once we get further down the road. Let me see here. Did I miss anything that we needed to address?
I have a couple questions at least.
Sure.
So the supervised visits is an informal third-party supervisor. Are these going to be limited to where visits take place or something like that?
My hope would be that the parties can agree on who that is, and then that they all agree that they'll find an appropriate location for those to take place. So I'm not requiring it to be at a certain person's home. I would hope that they can do activities and do other things like that, but just with a supervisor. And
then regarding transportation, I was trying to write as fast as I could and I missed the decision-making part and the transportation part. So I know you said joint decision-making, but transportation, I didn't hear that. Is that a picking up parent situation?
And I guess I didn't hear, I know that Miss Green requests that the, pickups and drop-offs be at the home. I don't know if there's a request for whoever, if it's his visitation that he picks up and drops off, or if you want to split that.
I think I guess my biggest concern, Your Honor, besides that, I'm sorry, is that if he's going to be providing either one of those legs and all 5 children are going at once, then
He doesn't have the
how
car.
it's going to work since he has a 5-seat car. So I'm just trying to think through this. Would it be that he can use the family station or the family minivan for the 2 hours in the Sunday afternoon situation? Normally I'd say, well, let's trade cars, but this is an employer car. She can't drive it. Right. And so that kind of limits our situation here. But because of 5 kids, that's one too many.
Miss Green, do you have a?
Mr. Ellis, I think, has a suggestion, maybe.
Well, actually, I had a question.
I'm going to talk to Miss Green. Okay.
Yes.
Do you have a response to that concern?
I am concerned about switching vehicles. I don't want to put any undue burden or leave my client without access to a vehicle in case of any situation. I know that these visits are for a matter of hours, but I don't want to cause any more conflict and issues between the parties. What my suggestion would be is if he's having supervised visitation, then he should be able to have another person with another vehicle. I understand that they're not going to be able to supervise all the children in the car, but there is a with father for the pickups and drop-offs. But my concern is that already the oldest child is not wanting to have contact with father, and so I do want to bring that to the court's attention. If it is going to be all the children visiting, that we are going to require the oldest child to participate and make sure we address, that there's no cancellations by father, that this schedule is going to be followed.
Okay, so that does throw kind of another wrench into things a little bit with the supervised. I'm not changing that decision. My hope then would be that whomever's willing to be a neutral third party supervisor that both parties agree to is able to help transport those kids. I am going to order that it's all children at this point. I haven't heard any reason whatsoever why 14-year-old doesn't want to be involved in these. There's some mention, and I know Mr. Ellis indicated he wasn't trying to force that issue. At this point, this is a court order. I would ask that the parties abide by that. If there is some, and abide by the schedule that's being set until otherwise addressed by the court. If for some reason we get to a situation where Mr. Ellis and the third party show up to the house and 14-year-old is unwilling, we'll address that hurdle when we come to it. I would ask that the parties address it as adults and realize that all of this is impacting the kids in different ways, and they're going to probably react in different ways because of everything that's happening. I frankly haven't heard enough information to just say, oh, 14-year-old's exempt. This is all the kids together to go see their father. If there's issues that arise, I'm happy to revisit that. But at this point, I think it's appropriate that all the kids are involved in this visitation. Do we need a presentation date?
Yes, Your Honor, I have another question for you when you're ready.
Sure, go ahead.
I hate to belabor this, but I don't want this to be delayed for visitation starting. Regarding the transportation, I don't think you said who picks up or drops off. It'd be helpful if Mrs. can do one leg of that, but additionally regarding the supervisor, if the parties were going to go to wherever, either back to his house or to the mall or wherever they decide they do other afternoons, can some children ride with father and some ride with the supervisor? Because again, you're putting if they all have to be with the supervisor and not with father, it's 5 kids have to be accounted for no matter which kind of car you figure out, is my point. So
Yeah,
it's an unusual situation, not running too much, but
I don't want to, the parties have to rent an 18-passenger van to get everyone to where they're going. Part of this, I frankly like to put on the parties to try to work out. If mom's willing, since she has the vehicle that's able, dad says Wednesday, okay, I'd like to be at the bowling alley. Mom takes him to the bowling alley and he's there with dad and supervisor. And if mom can pick up, the more mom can do to facilitate that, I think is great. If they have a supervisor that has a vehicle that can transport, or they can caravan between dad's vehicle and supervised vehicle, and some kids are in each, I am okay with that.
So I believe what's happened is father's generally picked up and mother has picked up the children at the end of the visits. So I would say that would be the standard, unless there is some agreement that they deviate, like she can pick them up and drop them off somewhere particular. So I just don't want it to be the burden on my client to have to support all the exchanges.
I think that's fair. So we'll assume dad will figure out the pickup and mom will pick up, meaning at the beginning of visitation, and mom will pick up at the end of visitation. However, that doesn't mean that the parties can't work together if mom's able to do both, and they agree to that. That's fine.
Thank you. So I'm not sure if Mr. Davis has other questions. I did want to make sure we had a start date and when the payments will be made for the family spousal and child support payment.
I'm assuming the mortgage and bills have been paid for this month by Mr. Ellis?
yes, that's my understanding, Your Honor.
All
And
right.
he's already paid her a couple weeks of he pays her every single week. He gets paid every week, so she pays her every week.
Okay.
I guess we have to figure out what that amount is since we're mid-month.
I guess, Ms. Green, are you comfortable working that out with Ms. Davis? Because otherwise I'll just say June 1st, since it's completely different than what's been happening. Or excuse me, May 1st.
So yeah, that would be my concern, is my client's going to go 2 weeks without any sort of income, because he hasn't paying her weekly. So I would ask for at least, I mean, we could talk to Mr. Davis if we're coming back for entry. I would say on the 9th, I would hope that at least, continuing the payments that have been made, and then on May 1st, that payment be provided so that she can make all the household bills and everything that are needed.
Okay, so I'll order that Mr. Ellis make his regular payment for the last week of April, which is next week. And then the family support amount start May 1st.
Okay, thank you.
All right.
Did you say May 9th is the return date? I didn't hear that, but I think Ms. Green just mentioned that.
That is the next available docket date. Miss Wade, we still have room on that date.
Sorry, let me check.
And I don't know if you want to deal with my last question. We're waiting, Your Honor.
Sure.
Yes, we do.
I'm sorry.
Yes,
Sorry.
we do.
The clerk indicated we have May 9th works. So
And so this is mother's motion. I assume she's going to draft the orders, or?
Well, we both filed motions, but I can draft the orders. Obviously the concern is always the cost, but I don't know if the court will split the cost for the drafting or not, because Mr. did file a motion as well.
Well, but I think they just struck his motion and moved this one forward. We'd asked, she's already going to be receiving the lion's share. I guess obviously there's arguments regarding what that's for and whatnot, but lion's share of the income.
all right, I'll have a Miss Green. Since we're essentially adopting the parenting plan that Miss Green provided already, I'd ask that Miss Green just finish the other couple of orders.
And the guardian ad litem costs, how will those be paid, court or Mr. Ellis?
Given that we didn't do the standard, I'm gonna set it at 50-50 now, and then we can reserve if there's concerns moving on. Just so we can get the process started.
So not pro rata then, Your Honor, 50-50, is that what you said?
Yes, because I didn't go off any. Well, I took all the worksheets into consideration, but I didn't do frankly, if mom would be paying more than dad,
Right. That's what
potentially.
I guess my comment was,
But at this point, I'm just gonna leave it 50-50.
The only other thing I think I have a question about is, so can my client, generally there's a protection to removing any funds from an account. Is my client able to remove the funds from the joint account that had been left for her into a separate account without Mr. Ellis having access to remove those funds? So we can separate them financially and deal with the rest at a later date.
I object to that, Your Honor. They've been so mixed and she's taken so much out. I mean, we'd have to do an accounting if we're going to talk about dividing what, originally was community funds. We'd have to figure out what amounts those are and whatnot. I mean, we can try and figure that out to see what is even left, much less, and who's taken what. I guess maybe it's a better idea, is a better accounting. I know you didn't want to get in the weeds on that, but if we're going to distribute that.
I don't know that I have sufficient information to do that at this point in time. But clearly both parties have accessed significant chunks of the joint account to do a variety of different things. I'm not saying anything good, bad, or otherwise about that. But I think there should be as much protection of the joint funds as possible moving forward. If there's a need for that and you can itemize what's going on, I'm happy to reconsider that at a later date.
Your Honor, my client has a question if the court would indulge.
I don't usually.
I know.
Represented. I don't know if you want to.
I don't know what it is, Your Honor, so I can't.
All right, go ahead, Mr. Ellis. I'll give you 1 minute.
Yeah, I'm not making a statement. I'm asking a question. The $5,200, do I pay that in one lump sum, or do I keep doing weekly payments like I've been doing? How would you like that?
Ms. Green, does your client have a preference?
Well, I think that there's a deadline for the mortgage to be paid timely. I'm assuming it would be around the 5th of the month. So we'd need at least the bulk of the payment to cover the house expenses. I don't know if,
How about this? Well, how about we do half by the 5th of the month? And the other half by the 16th of the month. That way it's just 2 payments a month of about $2,600.
Can I make another offer? And that is that I just go ahead and make the May 1st mortgage payment and subtract that from the 5,200. And that way she's got 30 days to get it changed over to her name.
No, but I appreciate it. Thank you. All right, anything else?
I'm sure there is, Your Honor, as usual, but
Yeah, well, we'll be back on the 9th at 1. So if there's any issues we need to clean up. Additionally, I also have presentations Friday mornings at 8:45. So if the parties see another issue that you need to resolve before we get the orders entered, you can always note it up for a Friday at 8:45.
I think, Your Honor.
All right,
that was gonna
thank
be
you.
my question. Thank you, Your Honor.
All right, good luck to everybody. All my notes on the actual order, so we can handle this today. Your email indicated that you agreed to the changes in the child support order. Is that correct?
Just one section, Your Honor. I
Just one
corrected
section?
section 22, which was one of the objections made about how our family would be used for payments. I just wanted to confirm that payments weren't going through the app. So I corrected that language, and we discussed that with Mr. Davis, and I think we had approval last night. So that was the addition we made, but there's still 2 issues before the court.
All right, so I'm gonna sign the child support worksheet. Child support order, I have section 19 and then section 22. 22 was agreed, so we still need to discuss section 19. Okay.
Correct, Your Honor.
All right, and that is the tax exemption. So go ahead, Mr. Davis.
Your Honor, did you, it sounded like you did receive my written objections or have read those?
I did, yes,
Okay.
thank you.
So just quickly, I don't want to repeat what you asked me to do in writing. The short of it, Your Honor, is they're requesting mother receive 2 and alternatively the other child every other year for tax exemptions. You know, future years may be an issue if mother finds a job and starts working at some point, but for 2023, we're at May already. There's no benefit in giving mother any sort of tax exemption. She has no taxable income. We had asked the court to impute her, and there was discussion about that, stating that she hadn't worked for some time, and there was 2 minor children. There was some discussion whether that would be fruitful or not. Employment, at least in the short term. The court did not impute her, and it gave her $5,200 in family support, which is tax-free to her. My client continues to pay the tax on that and his small remaining income of $1,500 or so, maybe a little less than that. And so that's the basis of that. She would have to earn substantial money in the last 5 months or 6 months that we have left of this year to even benefit from those tax exemptions. My client's income was calculated using the tax exemptions they have historically taken. His income would have been even lower as net if we knew that the child, 2 children, possibly 3 children, were not going to be included in that. And so that's the basis of our request. It doesn't benefit mother at all. She receives all that money tax-free. Father has to pay the taxes and all that. He's the only one that would benefit from that. Without those extra exemptions, his income's going to go a lot less than the $1,500 that the court's given him now. And so that's the basis of that. The other request on there is the January 31st, current on the payments issue. That's fine. One thing I failed to put in my notes to you was I'd like to have the deficiency notice sent out by mother on January 10th. So that way he can get current by January 31st. I've had that issue before there where people say, well, you weren't current. Well, it was a $25 bill no one told about, in the beginning of January when that could have been easily rectified. And then you have the court trying to decide if that's fair and whatnot. So no objection January 31st. I just wanted January 10th or 15th, whatever the court wants to put in their reminder of the deficiency if she's going to say that he's deficient in some manner. But the big issue with that, of course, is he's the only one that benefits from the tax exemptions and credits. He's the only one with income. He's the one paying all the taxes for her and him. We think it's justified that he receive all those for 2023. Now, if 2024 changes and she becomes, gainfully employed or whatever, that can be reserved, of course. And court, I don't have a problem with the court reserving that now if it wishes for future years. But 2023, it only makes sense to us to have father receive those exemptions.
Okay, Ms. Green. First, the currency notice by the 10th of January seems reasonable. Any concern with that?
That was why I added in section 22 that all the bills would be paid through our family wizard, because it tracks all the bills and the parties mark when they're paid and not paid. So, I mean, it's duplicative of what our family wizard offers. If she's providing him bills and vice versa, and they're marked paid, there shouldn't be any issue with knowing what is or isn't paid. So I haven't had that brought to my attention before. I don't think there's an objection, but I think it's just as easy for father to look into our family wizard and see if he's paid them all, if they're both using that app.
Okay. And then the 2023 tax exemption.
So for 2023, my client hasn't currently worked, but there's still more than 6 months left this year. So the issue is, if she does get gainfully employed, she only needs to make basically $5 if they're filing separately to have to file a tax return. It would be appropriate if she earns, I think the minimum for taxes would be $11,000 in the year, if my recollection is correct. That she would have a benefit, that the tax claims would be beneficial to her to claim the children. So I do believe that by having father basically be able to claim the children, it loses her the ability to become employed and to claim the children. Obviously, we'd encourage them both to file jointly for the tax benefits for both of them, not just for the children, but for the house and other exemptions. But if they aren't going to agree to file jointly, my client should have the opportunity to claim the children if she does work during this year.
We have very brief response, Your Honor. Not only is my client, he's already based his tax, withholdings 5 months, almost 6 months into the year now, counting on claiming the children as he had traditionally done. But most importantly, she'd have to claim, my client quickly did some research, and looks like the standard deduction for 2023 is $13,850 with a $2,000 child tax credit. She'd have to earn somewhere around $18,000 before that even benefited her tax wise. And it's not even that she says she's applied for jobs, made applications, or has a job coming up, or minimum wage job coming up, or it's all what ifs, if this may occur. She argued just the opposite in our temporary orders hearings, that she didn't have a reasonable likelihood in the near future to obtain employment. So, it seems to be opposite of what the court based its ruling on.
And Your Honor, if I could just note, this is standard language. Usually the parties do split these exemptions. So that's the only reason we put that in this way and ask for that credit.
I don't disagree. It's standard language, certainly, Your Honor, but that's for people that have jobs and income and whatnot. Here, it was argued that wouldn't be the case, and it's still not the case. So I think for 2023, and again, we're just trying to limit it to that.
Okay, so I've changed two different things here. So on page 4 under 19, I wrote 2024 and beyond for that first section, and then added at the end of that sentence, unless changed in a subsequent court order. And then on page 5, I changed the example. So for tax year 2024, must pay all 2024 support by January 31st, 2025 to claim on 2024, just to kind of work with how I'm wording this here. And then after the last line before section 20, I said for 2023, John Ellis will claim all children for tax purposes unless Heidi Ellis makes over $13,000 in 2023. If she does, it will revert back to the above plan. So if Miss Ellis is gainfully employed and is able to make at least $13,000 in 2023, then we stay with the split as above. If not, Mr. Ellis will for 2023 be able to claim all the children, assuming he's up on all of the support. All right. And then I believe there was no issues with the temporary family law order. Is that correct?
Yes.
No, Your Honor, sorry.
All right. And then parenting plan.
Yes, Your Honor, and then you saw that too. We objected to one section of the parenting plan, specifically paragraph 12 regarding transportation of the children. As Your Honor, I'm sure recalls, this was a situation where there was, 5 or 6 months of unsupervised visitation going on before the matter came before the court. The court had to consider whether they wanted to grant mother's request for supervised visits or not. The court ultimately ordered supervised visits to occur. I asked about transportation, primarily for the reason that my client didn't have a car big enough to transport all the children. They have 5 children. We talked about maybe using mom's car if necessary. The court responded, and according to the clerk's notes, that the more mom can do, the better. The children can ride in 2 cars if necessary. The clerk's notes also say court orders all children visitation and third party to help with transportation. So it's our understanding that that father was going to transport the children to wherever they were going for this visit with the supervisor. There's no question that it was to be unsupervised. The dispute seems to be now that mother is asking for certain children to ride with father, other children not to ride with father, or frankly, if the supervisor has a big enough car, no children ride with father is how I read that. We don't believe that was the court's intention at all. The court was certainly loose regarding the transportation provisions and getting to where they're doing the supervised visits with. They have multiple supervisors. It's not a professional situation in different people's homes and throughout the community and family members. We're asking the court to what we believe was its intention to allow him to transport as many children as possible, and the third party and or supervisor could help with the transportation if necessary. If mother would help, that'd be fine, but otherwise it was ordered that she would do the picking up transportation or on the back side of the visitation, excuse me. So that's my client's primary dispute. They want to limit his ability to even transport his children and whatnot, and which children he can transport. We don't believe that was the court's intention.
So I am reviewing your ruling on this matter. And when we discussed the issues regarding the driving, you did say that there was going to be a third-party supervisor. And specifically, it says that it threw a wrench in things. I'm not changing the decision. I think the third party should transport the kids or all the children at this point. So you stated specifically that the transportation was supposed to be provided by the supervisor. The issue is if there weren't sufficient seats, then father could transport any additional children. At this point, there's been conflict with the eldest children. We brought it up in court, but you didn't have enough information to make a decision at this point, or at that point. Without getting into the weeds with additional information, since the visitations have occurred, there's still been ongoing conflict with
Your Honor,
the
this is not
eldest.
before the court.
So,
It's strictly disputed.
I believe that my client is here if we want additional testimony, because you did state if for some reason we get into a situation where Mr. Ellis and the third party show up and the 14-year-old is unwilling, we can address that hurdle. So since we're entering orders, it's appropriate to bring this to the court's attention. First of all, that the supervisors are the ones that should be transporting the children. And secondly, only if there's additional need for seats that the children would be in father unsupervised. So okay. I would like to bring more information to the court's attention, but I understand it's not in the record.
So hold on, Mr. Davis, there's two things. So I have to apologize because the parenting plan that I reviewed didn't have any of this language. So I was a little concerned or confused, by the objection, because the one I have says supervised visitation provider shall provide transportation to allow all children to attend visits, and father may travel with children without supervision to attend visitation, and mother may provide transportation as agreed for the children. And then the one I received today says if there are not sufficient seats in the supervisor's car, only the youngest children that will not fit in supervised vehicle shall ride with father for transportation purposes. So now I understand, I guess, Mr. Davis's objection, because I didn't see where it was dictating who could ride where.
So for clarity, I did submit new orders on May 11th, and I expected you would receive those because we mailed them out on Wednesday a week ago. So those are the new orders and where the basis of Mr. Davis's objections lie, because we did make a number of agreements and changes. So I
received the May 11th orders today. So
okay.
just so you're aware. And I was provided the May 8th orders from the clerks yesterday. And then today I got the May 11th order. So I understand the concern. My assumption would be that older kids are probably going to hop in the supervisor's car if they're not wanting to be around dad, or if that's an issue. I'm going to, I'm striking only and youngest from that last sentence. So basically it will read, if there are not sufficient seats in the supervisor's car for all children, the children that will not fit in supervisor's vehicle shall ride with father for transportation.
Can the children choose who to ride with then? How are we, I guess.
Yeah, I'm not going to dictate that. If they jump into the supervisor's vehicle first and take a seat there, then I don't think, I guess I don't want, and I'd ask you to just let your client know this, Mr. Davis. I don't want your client to then start rearranging where everybody is. Let it just kind of happen. I understand that this is a weird transition, and then some of the older kids are struggling. That's expected. It's expected, and there could be other layers of issues beyond just parents separating. And I acknowledge that, but I'm not going to, I don't have enough information to go too far down that road. So hopefully it can just kind of be an organic thing, and the older kids beat the younger kids to the seats in the other car. Okay. Were there any other issues, Mr. Davis, in the parenting plan?
One other issue, same paragraph.
Okay.
Well, I guess I don't know. You don't have the one, the latest one, it sounds like, or maybe you do now.
No, I do now, yes.
It says, second paragraph on that one says there should be no verbal communication between the parents at the exchanges. While I agree that there can be distance and whatnot, there still needs to be communication when there's 5 children transferring. 2 of them are pretty young, I believe, 2 and 4, if I recall correctly. My concern with that is, while we both encourage our clients to limit, children specific only necessary things, it's just setting him up for a contempt, violation of the parenting plan situation. When all the kids are coming out and whatnot. So that's our big concern. I understand you normally prefer parenting plan app. I forget the name, Family Wizard, which is fine for most issues, but at the exchanges, sometimes those issues we need to communicate.
And Your Honor, just to remind you, this was a request originally from my client for a restraining order. The court denied the restraining order and did issue an order stating that father shouldn't come to the residence other than as agreed or for the visitation purposes. There is a level of conflict. My client did describe some pretty serious domestic violence issues. We're trying to do everything to avoid any kind of confrontation, conflict, or issues at these exchanges. We've put in there specifically one parent remains at the vehicle, the children can come to the vehicle. There are 2 younger children, the older children can bring them to the vehicle. There's no need for any contact or conflict between the parties at the exchanges, and that's what we're trying to avoid.
So I understand, Mr. Davis, the concern, but there's a supervisor there. So if there's, one of the kids is having some difficulties that can be relayed to the supervisor who can relay it to the other parent, I'm going to leave that language as it is in the order. And then if we get to a point where we're not on supervised visitation, I'm happy to readdress that.
And so for the record, I do want to make sure that you've entered the temporary family law order that was signed on 5/11 as well, because it reiterated changes that match the child support order. So I do want to clarify to make sure we're not entering separate orders that are not all from the 11th.
I took my notes off the old ones off the May 8th and then chucked them in the recycle pile. So I did sign the May 11th family law order, temporary family law order.
Thank you very much.
All right.
The only other thought that comes to mind is obviously we're here for another hearing. Objections were never filed timely. My client would ask for fees for having to attend a second hearing, just merely because a lot of these things could have been agreed to or resolved prior to our last hearing, and we wouldn't have to be here again.
Your Honor, we provided those objections to counsel at least one day in advance to her in writing. The court asked us to recite this and try and confer with each other to see if we could resolve some of the issues, which you did resolve a fair number of the issues, and tried to bring this back to the court where it's just the remaining issues you decided today. There's no basis for fees in our understanding, Your Honor, as it was that the orders that were posed changed multiple times, as you pointed out. And so there's no basis for fees. The court asked us to do this. This is why we're here. We accomplished what the court intended. I don't see that there's any bad faith basis whatsoever, especially when the orders are changing. His first proposed orders, as you identified, provided something else.
I'm not going to impose any attorney's fees for this. I asked for those to be in writing, given the length of our docket last week. So I'm not going to impose any fees at this point. So I'll deny that request. All right.
I believe that's all that was before the court, if Ms. Green can correct me otherwise.
Yes. That should
Nope, it
resolve
looks
all
like
issues.
just to enter those orders. So, all right, good luck to, right, Ellis and Ellis. That is 23300008308. And we are on we're reviewing a GAL report, which I received and have reviewed. And do we have, Mr. Davis is here. You received that report?
I did, Your Honor. Sometime last week, I reviewed it with my client, and I'd like to be heard on that report when the court's ready.
Sure. And Miss Ellis is here. Miss Ellis, if you're here, if you could unmute and state your name. I see somebody named Heidi Ellis here. I'm assuming that's Heidi Ellis associated with this case. We cannot hear you. Does appear that you're unmuted. Wait.
Oh, wait, now can you hear me?
I can hear you now. Yes.
Okay.
All right. So Ms. Ellis, did you receive a copy of that report?
Yes.
Okay. All right, Mr. Davis, go ahead.
Your Honor, I know you read the report. I won't repeat it entirely. We want to thank the GAL for the report, especially in the time the court gave her to do this interim report. My recollection was this report was simply an interim, or we expected to possibly be oral, regarding whether the supervision should continue or not, in this case, pending a final report down the road. It's our understanding that she is recommending supervision continue. We object to that. The basis of that is my recollection and understanding from all the previous allegations is it was a close call. The court wavered whether it wanted to put supervision or not, but there was allegations about Joseph that were concerning, admittedly, if they were true. And so the court used caution and put supervision in place. As the GAO report indicates, it looks like the parties have agreed to let Joseph not do visits right now until he attends reconciliation counseling and whatnot. So really the visitation at this point is only among the 4 other younger children. As the court may recall, this was a situation where the parties separated in October of last year. Father had regular visits with all the children, including overnights, except Joseph, through May until the court put supervision requirements on it. Again, it was unsupervised by agreement of the parties throughout that process. Our opinion is that supervision should go away as to the 4 youngest children. At some point, if Joseph resumes visitation after reunification counseling, then that, we guess we could discuss that, or just put that in the plan and reserve it automatically. If he has visits, that's to be supervised. But we don't believe there's a basis otherwise, because the allegations were almost, if not entirely, about Joseph. As you might understand, this is a severe hardship on everyone, including all the supervisors that have to do these visits. And so that's our request, Your Honors, to resume unsupervised visitation at this time, and pending the further report. The report itself was based primarily on father and peers, because that's what the court's instructions were, an interim report regarding supervision, where you look forward to the additional report regarding mother and the parenting of both parties, et cetera. We would normally see in a final report. But until then, we don't believe supervision should continue as to the 4 youngest children.
All right, and Mr. Davis, you're indicating that there was a switch from unsupervised to supervised. I only show that one parenting plan, and it's always been supervised.
Let me clarify that, Your Honor. No, the court's order was supervised on that parenting plan, May 16th. The court's never ordered unsupervised. What I was referencing is the parties separated in October of last year.
Okay.
We have one of the parties filed earlier this year, Mrs. Ellis. Until our hearings in May, I believe it was, supervision was never requested from the court, or certainly ordered by the court regarding the children, and father enjoyed visits for that 5 or 6 month period, without supervision. And so the extent of the allegations were about Joseph, and that's why the court's order itself on May 16th and the signed parenting plan required supervision. But since Joseph is not visiting currently right now and going to go through reunification counseling, we don't believe that is needed as to the 4 other children, at least.
All right. Thank you for clarifying that. Miss Ellis, do you have any response?
I think the 2 youngest would be fine, but the 3 oldest, I think would still like the supervised visits, is what I understand from them.
All right. Anything else, Miss Ellis?
No, just that I think from the beginning before court, yes, they were obviously unsupervised because we never went to court about it, but attending court, whatever, that was, the first ruling was supervised visits. And so Joseph's not the only one that was affected. The 2 older girls were affected too. And the Carly, asked me why does she have to visit her dad because she witnessed, the incident that happened.
Okay. All right, thank you. Ms. Turnbull, anything you want to state?
Well, I do think getting a little bit more information from the domestic violence assessment will be helpful. Carly did specifically say to me that she would like the visits to continue to be supervised. Rosabella did not state a preference either way, but given the history with Carly and Joseph, that gives me some concern for Rosabella as well. Fathers, I think I mentioned in the report, some of his collaterals did express concern for father's discipline. And so that was one of the things that gave me concern. And the younger children may be okay, but if father's under stress with all of the kids, that is a concern I have.
All right. Well, here's where I'm at. I'm not seeing anything that would make me change to unsupervised at this point in time. I understand everybody's position, and I respect everybody's position. I frankly wouldn't be opposed to the splitting it up, the 3 eldest supervised, the 2 youngest unsupervised, if I didn't think it would be a complete and total logistical nightmare. There's already been all the concerns, maybe transporting 4 kids versus 5, since the eldest isn't participating in visitation, has helped a little bit with that. And I understand that there's the good graces of other folks that are supervising this. But until I have more information, I think I'm going to leave everything where it's at. If the parties, so if Miss Ellis and Mr. Davis have a conversation and there's an agreement to have the 2 youngers sort of split out from the 3 elders to do a different visitation unsupervised, and the parties agree to that, I'd happily sign off on that. But at this point, in the middle of a docket, knowing how difficult it was to find the times and places for all 5 kids to have visitation, I'm going to leave it as is. If Miss Ellis and Mr. Davis, you want to put your heads together and come up with a plan for the 2 youngest to have unsupervised, that's great. And it sounds like the GAL is more concerned about the 3 eldest as well. So those 3 will remain supervised.
Couple questions, Your Honor.
Sure.
First is the GAL recommends father attend domestic violence evaluation, which is already completed. We just don't have the report yet, to my knowledge. Secondly, she also recommends that Joseph, the oldest son, who most of the allegations are related to, attend reconciliation therapy. We're asking the court that the court require that, and we recommend Molly Tapany, who is a licensed counselor in the state of Washington, is my understanding, and both parties are familiar with her. I don't know what Miss Ellis's position on that is, of course, but that was our suggestion. But the main thing is to require Joseph to go through reunification counseling. And obviously, father has done everything to comply with Miss Turnbull, and certainly would continue to comply with whatever Miss Tapany or whomever the counselor is, so that process can get moving forward as quickly as possible.
Miss Ellis, any position on, and I'm sorry, I didn't catch the name of the individual that Mr. Davis proposed, but
Yeah.
reconciliation therapy.
Yeah, Molly Tapany. I know Joseph's really opposed to any sort of counseling right now. He's still, I think, has a lot of things to work through. So I don't know if we can just go into it gradually, or maybe take some more time and then do it. But I don't know if it would just push him away further. I'm not sure.
I understand her concerns, Your Honor. However, I don't know that we get anywhere, certainly with the court continuing supervision requirements as to the other older children at minimum. Again, based primarily on the Joseph situation. We're asking the court to require him to participate in that, whatever the counselor says or what that involves, of course, would have to be determined, but otherwise it doesn't sound like he's going to do it. And so we're stuck. Our hope is that some of this can get moving forward. Obviously the DV evaluation, I think should be completed any day now, but we need a lot of this to get done before the final GAL report, if possible. Reunification counseling, of course, may obviously go beyond that, may go on for who knows how long, but that's our goal. I mean, our goal is to get unsupervised and more time again, like we previously had. And right now we're really limited.
Let me see here. Final order August 16th. Okay. Sorry, I was looking for that next date in the GAL report. So historically, teenagers, my experience with teenagers, and I have a fair amount of that with my prior position. Forcing counseling 9 times out of 10 doesn't work. I understand you're in a position a lot of times where you need to force it in the hopes that it does work. And when I say counseling, I'm not talking about, drug and alcohol, that type of stuff. I'm talking about, actual counseling and different mental health type services. I'm sure the event was rather traumatic. I am a little deferential to Miss Ellis and her concern that maybe it's a little too soon to start that. And frankly, I mean, if we're going to just get down to brass tacks, the person that Mr. Is it Joseph is the oldest, that Mr. Joseph Ellis is going to blame for any of these issues is going to be Mr. Ellis. And so that's not a position I'm sure he wants to be in either, but I understand he wants to see his son and work those things out. I'd like to do kind of more of a graduated thing. So what I'm going to, Miss Ellis, I'm going to indicate, and I'm going to ask Ms. Turnbull to sort of help with this process. I'm not opposed to whomever the parties can agree on, if they agree on anyone. But let's give it a few weeks, and let's set Joseph to, let's try to get a first appointment in with a counselor by July 28th. And just see how that goes and start the process, provide feedback to Ms. Turnbull. If that goes well, then let's move forward with reunification counseling. But frankly, there could be other things going on that need to be addressed before we worry about reunification counseling. So I want to make sure, but I also know that kids can be very oppositional in these situations, and I do want to ease him into it. There's some choices that he can make and some choices he can't make, unfortunately. But if I force him into counseling right away with Dad, I'm not the bad guy. Dad's the bad guy, and we don't want to set him up for failure that way either. So Miss Ellis, if you could get him into an appointment by the end of July, get some feedback from that individual. So if we could do a ROI with Ms. Turnbull, so she can incorporate that information in, and if we can segue and start reunification counseling shortly thereafter, great. If not, we'll address it when we return on the 16th of August.
Okay, yeah.
Do you want that appointment to be with Ms. Tapani? Or is that open to Ms. Ellis's discretion?
I don't, is Miss Tapani someone who can do reunification counseling?
My
Sure.
information from my client, Your Honor, is that she can. I don't think either party has actually worked with her in the past, but everybody knows of her in their community. I don't know if Miss Ellis necessarily even opposes that. It sounds like more of it's a Joseph issue, but voluntarily doing or participating in it.
Miss Ellis, do you have any concerns with Miss Tapani?
No, I don't. I've heard of her too, so.
Okay, well then let's, I guess, let's shoot for her and see if we can, if she's available for this. If for some reason she isn't in the time frame that we're working with, then get an appointment with whomever you can get an appointment with, and just let Mr. Davis know.
Okay.
All right. And then we are, looks like we are back August 16th at 1 p.m. for a final report. And Ms. Turnbull, if anything is holding that up, just let us know. And if we need to bump that around, we can do that.
Okay, thank you.
All right. Thank you. Good luck.
One last request, Your Honor.
Yep.
My client has had trouble getting the child support to GCS set up. We're just requesting Miss Ellis continue to communicate with them so that can get it set up. Otherwise, she's not going to get July's payment in time. So she can call me or email me if she wants to figure out how to do that or what's necessary.
Make sense, Miss Ellis?
Sorry, cut off at the beginning. Get a hold of Mr. Davis for the payments.
Yes, child support. So complete all the DCYF stuff for child support.
Okay.
Okay.
Thank you, Your Honor.
All right. Thank you.
Thank you.
Thank you.
There's a phone number ending in 7402. Can you tell the court who you are and what case you're here for?
This is Ellis, and my case number is 233-000-8308.
And what is it? Say your first and last name again.
John Ellis.
You see this individual on your docket? I am not seeing it. I'm not seeing you on our docket. Is it a family law case, sir?
It is. I received a notice of hearing on August 23rd at 3:42 p.m. via email from the guardian ad litem, Amy Turnbull, stating that the court hearing had been scheduled for September 13th, 9 a.m. on the self-represented A docket. Now, I questioned her because our case number says we're supposed to be on B, but she never replied back. So this is the notice of hearing, and here I am.
Okay, totally understood. Let's see if we can make sure we get you in the right place. Do you know who's doing self-represented tomorrow? If anyone. Oh, there we go. Okay. Yeah. Yep. Oh, you are. Okay. So John, we did find your case. Unfortunately, what the guardian ad litem gave you is just 1 day off. You are correct that you should be on the B docket. So that is tomorrow at 9 a.m.
So a couple of questions, and I guess since I'm not on your docket, I can't really take any of your time, but this is not a mistaken date. It clearly says the 13th and self-represented A docket.
Yeah.
Should I not have received a new hearing notice?
I cannot answer that for you. I don't have your
Okay, how about
documents
this
in
one?
front of me.
How about
So
this
here's-
one? Amy Turnbull is
Sure.
neither the petitioner nor the respondent.
Yep.
How is she able to set up hearings when neither the petitioner
Sir?
nor the respondent wanted the hearing?
So, sir, I'm not the judicial officer who will hear your case. It will be Judge Warning tomorrow. Please bring up any questions you have with him tomorrow because he'll have your entire case in front of him. Okay?
Thank you for your time.
You're welcome. Thanks for logging in.
Heidi Ellis and John Ellis.
John is present.
And Your Honor, this is Amy Turnbull, the guardian ad litem.
And Heidi Ellis is here. Can you hear me?
Yes. Where is Johnny Davis?
Johnny Davis is no longer representing me.
When did that happen?
Several weeks ago.
Okay, well, he hasn't filed a withdrawal with the court as yet.
He did. That is.
Oh, wait, here it is. All right. Okay. We are here to discuss the guardian ad litem's recommendation. And have both sides had a chance to see that?
Yes.
Yes.
And let's see, Mr. Ellis, do you have any comments you want to make on that?
Well, I did file a declaration in response to the guardian ad litem's report back
Yes,
on
sir.
August 14th.
I've read
There's
that.
nothing different in there. Nothing different in there.
Okay. And Miss Ellis, is there anything you want to say about it?
I know I replied back to it, but it's just, I guess, everything I said in there.
All right, Ms. Turnbull, anything you want to add?
Not at this time.
And so it's been a little over a month since that report was filed. Have there been any new developments, anything unexpected? Ms. Turnbull?
Oh, I'm sorry. Not that I'm aware of, no. I mean, I will say that Mr. Ellis is motivated. I think it got to, attend the therapy. He is in compliance, and by all accounts, he's motivated to attend and to change. I do think he has some work to do, to maybe get there.
All right, so Mr. Ellis, from your standpoint, are there any specifics in the guardian ad litem's recommendation that you have a concern with, or you think aren't working or won't work?
Well, without rehashing what was in the response about my concerns on the guardian ad litem's fulfilling of her duties, I had really hoped at this point that we would have something worked out with not requiring supervision. The guardian ad litem said that it was not necessary for the young ones. The court did leave it to Heidi and I to work out a change to the parenting plan, but we were unable to come to a consensus on that. Heidi would like to keep all the kids together, even though I don't see all the kids together. They're already split. I am not able to use the parenting time to its for what it's designed for, which is to develop a relationship between myself and my kids, because I have two very little ones and I have two almost teenagers that I see weekly. One I do not see at all. And I'm off tending to diapers and playing with little kids and reading books, which I absolutely love, don't get me wrong. But my older kids, I don't get to see them during the parenting time. They take off and go play with their friends. I would like to use the no supervision required time with the little ones to see them during the week, and use the supervised required time to see the older ones on Sundays when the little ones are not present, so I can build that relationship with each of the age groups.
Sir, what's your position about the moving your daughter's time to a different day?
So some of this Yeah, sorry. Some of this has changed since the court order, as well as since the guardian ad litem's report. The court order did allow for written modifications between the parties, and Heidi and I have been communicating regularly through our Family Wizard app, and we have made changes. I now see the kids on Mondays and Thursdays from 6 to 8 p.m. and every other Sunday. So it was just a change in days, not a change in time or supervisors. That was to allow for my DVIT counseling that I self-engaged in, have been in for 2 months, even though there's no court order, as well as the kids wanted Fridays for friends. So that frees up their Fridays for them.
All right, and Miss Ellis, is there anything about the guardian ad litem's recommendation that you want to address specifically?
No, just that my older daughter would still like to remain the visit supervised.
What's your
And
position about supervision for the younger children?
the two youngest seem fine for short amount of time. But I don't agree with splitting them up. On those visits, he does have time to, I believe, to visit with the older ones. And I know I don't know, I guess, like visiting with the adults instead of the kids. I don't know.
Ms. Turnbull, any comment on the supervision?
I think it may be reasonable to try giving Mr. Ellis some time with the younger ones because of the age differences, unsupervised with the two younger ones and supervised with the older ones. I think at the previous hearing and Ms. Ellis has been, I think generally okay, generally comfortable with the idea of Mr. Ellis being okay for short periods of time with the younger ones. So maybe 2 hours once a week.
Physically, how are we going to accomplish supervision with the young or the older ones, but not the younger?
I would offer to do that on separate days. Maybe one night a week, he just sees the younger ones. And then on Sundays, for example, he has the older ones. And have 2 separate days. He might, perhaps the parents could weigh in on something like that, but.
Mr. Ellis, let me ask you first, you're more familiar with everybody's schedules. If we were to go to a system of unsupervised visits for the 3 younger, at least once a week, and maintain the supervised for the older, how do you think that would lay out? How would that work?
So I have had a time in the past that resulted in no visitation because I couldn't have, no supervisors were available. I increased my slate of supervisors to hopefully avoid that, but it is very common for weekdays to be difficult for supervisors. Sundays are no problem.
Hang on. I'm asking you something a little different. If we were going to go to a system where at some point during the week, say one day a week, you had the 3 younger kids unsupervised, what would work from your standpoint?
The existing days of the week are the only days that I'm available because of the DVIT class.
Okay,
so it would be one of the
Monday, Thursday,
it would be one of
Sunday?
the Mondays. Yes, I have Monday, Thursday, Sunday with them right now. I had proposed the older kids on Sundays because that's easy to get a supervisor, and the younger kids on the weekdays, unsupervised.
All right, Miss Ellis, what do you think of that proposal? So Monday and Thursday would be visitation with the 3 younger children, unsupervised. Sunday would be all the children supervised.
Yeah, right now it's every other Sunday.
I'm sorry, ma'am, something good.
Every other Sunday he has them. Are you saying he has them every Sunday?
No, I'm not changing.
Oh, got it.
Time. So just the Sundays where there is visitation would include all the children and be supervised. The Monday and Thursday that is currently supervised with the younger three would be just the younger three supervised or unsupervised, pardon me. Is that,
Yeah,
what's
that
your
would,
reaction to that proposal?
yeah, that should be fine. I mean, that works for me.
Okay, Ms. Turnbull?
Your
Does
Honor,
I'm
that make
comfortable with
sense?
that.
Your Honor,
Yes, sir.
that reduces my time with the oldest children by 4 hours a week.
Well, that's
And,
why I asked
makes
what your
me old.
proposal was. So,
Well, my proposal was oldest only on every Sunday, which would be the same number of hours, and youngest only on weekdays, not Sunday. Because if I have all of them on Sunday, then it's no different than today. I can't create that relationship with the older ones.
all right. And Ms. Ellis, so I think I understand Mr. Ellis's proposal, and so it would be just the older children on Sundays supervised. Is that right, Mr. Ellis?
Every Sunday, supervised oldest children, yes, please.
Okay. So Ms. Ellis, what's your position on that?
I know the oldest would not like that. They, I think they would rather do the every other Sunday, because I know they commented on it before when I asked them if, they would like to do every Sunday see dad, because I think this is what we talked about before, and they did not like it.
Okay. All right. So folks, based on what I have read, obviously, Mr. Ellis appears to be working hard at it. There's a lot of work to do in the relationship with the two older ones. Mr. Ellis, I understand your desire to expand that visitation. I don't want to do anything that's going to be counterproductive. And at this point, I think making that change is probably going to generate more dismay or resentment in the older kids. And I think that's one that's going to have to come down the road a little ways. You can still petition for that whenever or make a motion for that whenever you think appropriate. But at this point, what I'll order is we continue on the current schedule with the following modifications. Mr. Ellis will have the three younger children on the Monday and Thursday visits unsupervised. And then on the alternate Sundays, we'll continue visits with the two older children only, and that will be supervised. And we'll need one of you to prepare that order. And that parenting
I can
plan.
prepare it exactly as, I can prepare it exactly as you've stated.
All right, and we'll put it on in 2 weeks then on the same calendar for presentation. So Mr. Ellis, if you'll forward that to Ms. Ellis, ma'am, if you look it over, if the proposed parenting plan you think accurately reflects what I just ruled, go ahead and sign it. And then between the two of you, get it to the court and we'll see it get signed. If not, we will be back here on the 28th of September at 9 o'clock for presentation.
And may I ask for a clarification, Your Honor?
Oh, you can in just a second. Mr. Ellis, though, when you do send that parenting plan to Ms. Ellis, make sure it goes to Ms. Turnbull as well. Right, go ahead, sir.
Yeah. Yes. So I received a notice of hearing from Ms. Turnbull on August 23rd at 3:42 p.m. by email, which was our approved communication method.
Okay.
And it stated that our hearing was yesterday. I never received any other notices of hearing from Ms. Turnbull or other communication using either the email, which was approved, or my P.O. box, which is my mailing address. So can I use email for this thing for Ms. Turnbull and Ms. Ellis on the presentation of order? Will they agree to that?
Email fine with you, Ms. Turnbull?
Absolutely. And Mr. Ellis, I did mail you an updated notification. I'm sorry you didn't receive it.
Okay. And
Yeah, I get copies of all my email or all of my mail before it hits my P.O. box, and there's nothing in the mail.
All right, and Miss Ellis, email okay by you?
Yeah, if he has my correct email address, I think he does.
What is that email address?
I'm assuming it's the one she's communicating with Amy Turnbull on. I've been copied on those. Is that correct, Heidi?
Yeah.
All right.
And I just had a question about, you said the two oldest, does that mean our oldest son?
Well, he is not visiting right now. And I think everybody's position is that that's going to remain that way for a little while, correct?
Yeah.
Okay.
That's voluntary. It's not part of the order.
Understood.
I'm following that as voluntary. Yeah.
Yes. All right. That will be all until the 28th then. Heidi Ellis and John Ellis.
Here.
John's here.
And this is Amy Turnbull, guardian ad litem.
And I've got a proposed order that appears to be signed by both Heidi Ellis and John Ellis.
That's correct.
So both of you signed that?
Yes.
All right.
That's
I will go ahead and sign it.
Thanks, sir.
Thank you.
Thank you.
Heidi Ellis and John Ellis.
John
Yes.
is present.
So, Mr. Ellis, as near as I can tell, you don't like the parenting plan that got entered.
No, you and I and Heidi and the gal met to review the guardian ad litem's final report about 2 months ago.
Mm-hmm.
And in that, the supervisors were removed for the three littlest children. And at
Mr.
the
Ellis?
time, yes. Yes.
Go ahead.
At the time, you didn't want to make changes to any of the days or hours, but you did want to give me the unsupervised time with the children. And the end result was that my time with the children was cut in half across the board inadvertently. You suggest that I could submit for a new parenting plan. All I'm doing in this proposal is trying to get back the same hours that I had previously to the removal of the supervisors.
All right. And so now let me finish what I was saying. In order to make a change to the parenting plan, you've got to file a motion to modify. You have to give Miss Ellis notice of that and provide proof that she's been served with that motion, and a notice of hearing showing when it's going to be on for. So unless and until you do that, there's not much I can do. I understand that the process through the court system, the pleadings that are necessary, is kind of confusing and daunting to somebody who doesn't have experience with it, but I am required to follow those rules. So if you want to change the parenting plan that was entered in October, you've got to file a motion. You've got to support that motion with whatever reasons you think are appropriate. You have to set a hearing, and you've got to give Miss Ellis proof of those things. You understand that?
Okay, I believe I've done all that. So can you help me? I submitted
There's
a
no
proposed
motion.
parenting plan. I'm sorry?
You submitted a proposed parenting plan. There's no motion. There was no notice of hearing. I've got no proof any of it was served. So without a motion to modify the parenting plan, I can't do anything.
All of those were done. The parenting plan, the declaration, the motion was the cover sheet on this. We set the docket. We served both the
Mr. Ellis,
guardian ad litem. Yes.
Ellis, I don't know how else to tell you this. There's no motion that was filed to modify. Absent that, I can't do anything. So that's where we stand. If you want to pursue it, you need to file that motion, serve the motion and a notice of hearing, and then I will happily look at whatever it is you're requesting. That will be all for today.
I have a question really fast,
Yes, ma'am.
because I was gonna ask for a continuance because our GAL couldn't come to this hearing. Should I just cancel that continuance
I'm
then?
not going forward with any motion today, so if there's one filed in the future, I will look at it.
Okay, thank you.
Heidi Ellis and John Ellis.
John is present.
Yes.
And this is Amy Turnbull, the guardian ad litem.
Ms. Turnbull, let me start with you. Have you had a chance to review the motion?
Yes, I have.
And have you got a position?
I understand Mr. Ellis would like more time with his children, and that it was cut. My concern is I have been in communication with Mr. Case, who is Mr. Ellis's DBIT counselor, and what he communicated to me is that he is not in support of unsupervised, overnights or unsupervised visitation with the children, particularly the older children, or unsupervised overnights with the younger children.
Okay, let me ask you specifically about that, what the position was as regards to the two oldest versus the three youngest.
Yeah, in fact, what he actually said is, I can actually read you the statement, the email.
Please.
He said, I do not believe that Mr. Ellis should be granted unsupervised visitation with the three younger children. My stand on the two older children is that they are given whatever they may need to feel comfortable having unsupervised visits with their father.
And at this point, to your knowledge, will the oldest boy, is he willing to visit at this point?
My understanding is no.
Okay. All right. Anything else you want to tell me, ma'am?
One of my concerns is that, I know Mr. Ellis would like more time with his children, and I think that the professionals in this are maybe a little bit more hesitant, given some of the feedback from, Mr. Case and the children. I think it might be helpful to have some professionally supervised visitation so that we can get some feedback from the supervisor as to what the interactions are like between Mr. Ellis and the children, and perhaps 4 or 6 visits to get that feedback so that we know what's happening and can give us some assurance.
And have you got any information on how the unsupervised contact is currently going with the younger children?
I don't have an update recently.
Okay. All right, Mr. Ellis, is there anything you want to tell me in addition to what's contained in your motion?
Well, being that Ms. Turnbull did not file a written response, I didn't have time to see what she was going to say. So I'm a little shocked, because that is actually the opposite of what Sam Case told me at my counseling on Tuesday. He said he absolutely was in support of the youngest children not needing supervisors. He did say that he was concerned that the oldest children should have a say in whether they visit or not, which I have been giving them. So I'm going to have to follow up with him as to why the email he wrote to Ms. Turnbull was what she reported. But
And
as for the
Mr. Ellis, what is going on with the two older children in terms of visitation?
I still text Joseph and tell him I love him and that he's doing good. And I asked if he would like to attend. Yesterday was my birthday. I asked if he wanted to come to my birthday dinner, and he said probably not. So I respected that and just had a phone call with him. And the Carly has come when she wants to, which has been, according to her, all of the opportunities except for when she's sick.
Okay, which is how often, sir, has Carly been coming?
Well, when the supervisors were removed, I ended up only getting Carly for every other Sunday. So it has gone sometimes 2 weeks, sometimes over a month before I see her.
Okay. All right. Anything else you want to tell me, sir?
Yeah, if there is a consideration for professional supervision, I would ask that the court consider how that is going to be paid. because the court, not yourself, but the previous judge, ignored the state requirement to not go below 125% federal poverty level for a one-person household and placed me well below that with a combined family support payment that gives nearly everything to Heidi.
All right, and Ms. Ellis, do you have anything you wish to say?
I know that Carly still struggles with going to see her dad. And it's kind of a fight every other Sunday. And so I think the main thing is she doesn't want to go by herself. But I know it's supervised and she's more comfortable if it's a supervisor she knows, like, you know, friend's house or whatever. And then I think that was it.
Okay, so folks, here's what I want to do. So you understand, I am just back here on a temporary basis, kind of helping fill in, and that's scheduled to end at the end of the year. I want to get this temporary parenting plan issue resolved rather than just dropping it on somebody else. So I'm going to put this on in 2 weeks, on the 21st at the same time. Between now and then, Mr. Ellis, I'm going to suggest you contact your counselor. You'll probably need to sign a release of information. And ideally, what I'd like to have is some sort of a report or letter or something from the counselor with their position both on where you're at in the counseling and what they feel, yay, nay, or otherwise as regards your requested visitation. You understand that?
Is this in regards to the overnights or the supervisors or all of it?
To everything. If these,
and so
anything that he's got a position about, I would like to know what his position is.
And so am I to understand that I'm still not getting back the time that was taken away from me when the supervisors were removed?
That's going to be decided on the 21st. Given the discrepancies here, I want to make sure I know what's going on before I just willy-nilly make a decision. So we'll put it on the 21st, get that information so that I've got it in front of me then, so we can get this issue sorted out before the end of the year. Understood?
Okay, what ROI are you looking for?
Anything that the counselor thinks is pertinent to your requests.
But I mean, there's already an ROI in place with the guardian ad litem and the DV counselor and my weekly counselor. Do you need one for you?
No, whatever your counselor says you need. He may say, before I write something to the court, I want another release of information from you that allows me to do that.
Okay, so as long as he's satisfied, he can write it, then that's fine.
Yeah, I just bring that up because maybe it's perfectly fine as it is, or he may have some concerns and you just want to make sure those get addressed so he can give me the information I'm hunting for. Understood?
Yes, and will you please clarify for me? The court rules state that all responses must be in writing. Is the guardian ad litem exempt from that requirement?
An awful lot is exempt from that requirement, frankly, in the pro se cases, because it's would not work otherwise. It'd take us forever to get anything done. And yes, the guardian ad litem is exempt for that requirement.
Thank you.
Okay, the 21st then at 9 o'clock.
Yes, sir. Thank you.
Thank you, Ronnie.
All right. Heidi Ellis and John Ellis.
I'm here.
And John is here.
And Mr. Ellis, the hope was by now we'd have an update from your DV treatment provider.
That has occurred. It actually occurred about an hour after the last court hearing 2 weeks ago. The guardian ad litem submitted an email to me apologizing because she had misread his email to her. I have submitted both her email admission as well as a discussion on what was actually in there, as well as his letter that you requested.
Okay, take a look at this. I had prepped this. I had to prep this docket a couple of days ago. This wasn't there yet, so let me look it over.
No, it didn't come in until Tuesday evening, sir.
All right, so Miss Ellis, anything further that you wish to say?
I guess I do want to go with the professionals' recommendations. I know what I feel, and you know, not really comfortable with unsupervised visits with the older ones yet, but whatever the professionals feel is best also is what I want. I just want what's best for the kids. So.
And Mr. Ellis, anything else you wish to say?
No, I believe it's all in there, other than I do wish to thank the guardian ad litem for catching that. And I did get a copy of the original email, and I too misread it, even though I knew what it was supposed to say. It was very hard to read. I'm sorry, sir, if I could also add, I was pleasantly surprised that my oldest son did want to visit. I got a 44-minute visit with him on the Saturday, last week Saturday, and it was in the presence of our preacher, and he helped to guide the conversation, and it was Joseph's choice. So that was a nice surprise.
All right, and let me ask you one question. In your proposed parenting plan with the 3 younger, you've got Monday, 4 p.m. to 8 p.m. every even week number. What do you mean by every even week?
No, I'm sorry, that's not. It says and every even week number, Saturday 4 p.m. to Sunday 6 p.m. So the Monday 4 to 8 p.m. is weekly. So it says every Monday.
And every even week number.
Right. So on a calendar, the weeks are numbered beginning with the full week of the year, January 1st. Our Family Wizard, Google Calendar, Outlook Calendar, they all support week numbering. So that's what I'm referring to.
Yeah, there's an even week number system.
Correct. Yeah.
You can tell which one you mean.
Right.
Okay.
I mostly just wanted to differentiate here that they were the opposite weekend of the other group of kids. But this was all created before the counselor's recommendation that supervision not be required so long as the children have whatever they feel is necessary for them to be comfortable with that. So although this is the way I wrote it, I would love to see if we could actually have normal visits without a supervisor, but that's not what was written.
Younger children, I'm going to adopt Mr. Ellis's proposal. So it's every Monday, 4 p.m., 8 p.m., even week for the Family Wizard, Saturday at 4 to Sunday at 6.
Wait, figure it out.
Ma'am, whoever is out in the booth, if you will please keep quiet until your case is called, I appreciate it. As to the 2 older children, I'm glad things are going better. Frankly, my assumption is that the presence of a third party probably helps with that. And I don't want that to go away too soon, because given the ages of the older kids, to some extent they don't get to make the decisions, but their reaction to the decisions that get made are very important. So I want to maintain the current schedule, or pardon me, the schedule as proposed by Mr. Ellis, but it will continue to be supervised. And as it sounds like maybe the pastor is a real good person to facilitate that. Ms. Turnbull, was there anything you wish to add? You're still muted, ma'am.
Thank you. I was in the waiting room, but admitted late, so I didn't hear all that transpired, but I think what I have heard sounds reasonable.
Okay.
So far.
All
And I
right,
apologize for my mistake the last hearing.
I understand it, and as Mr. Ellis pointed out, he had the same reaction when he first read it as well, so. They're just confusing language. The one difficulty I've got, well, wait, let's see if that, let me look at the proposed plan.
For detail?
And this won't be a problem. Okay, so I am gonna go ahead and sign the proposed,
Here for a 9 o'clock appointment?
maintaining the language about supervision with 2 older children. And that can go into effect immediately then. What provision have we got for the Christmas holiday?
There is no provisions. Heidi's out of town with the kids right now. She will be back, I believe. Well, she's on the phone. She can tell you when she's going to be back.
Miss Ellis?
Yes, I'll be back Sunday.
Okay.
We'll just make it up another time, Your Honor. I'm sure that's okay.
All right. All right. Thank you, sir. Frankly, it sounds like things are getting a whole lot better just based on the presentations I'm hearing in the course of these hearings. I hope that continues, and good luck to both of you.
Thank you, sir.
Thank you.
And
Thank you.
I thank Karen.
Next, I have Heidi Ellis and John Ellis, 23383-08. I'll ask if Heidi Ellis, if you're on the line. Right, Mr. Ball, are you on the line? Okay, no response from either. I'll ask if John Ellis is on the line. John Ellis?
I am.
Okay, welcome. Okay, welcome to you, Mr. Ellis. Just again, let me just call out the name of Heidi Ellis. Heidi Ellis, if you're here, please state your name. And Miss Ellis, if you're on the Zoom call, I'm not hearing you, just so you're aware of that. We have Miss Turnbull on the line. I recognize that she's present. And then Mr. Ball, it looks like you're on the line. Are you here? Okay.
Good morning, Your Honor.
Good morning. Yep, I can hear you. Great. All right, and just double checking with you, Mr. Ball, is your client going to be joining us today?
Yeah, she's on the line there.
Yep, I'm here.
Okay, all right. Okay, we are here related to Mr. Ellis's motion regarding a change of the parenting plan. And so at this point, I'll hear from him, and then we'll hear from Mr. Ball, and then from Ms. Turnbull.
Your Honor, I have nothing other than what was already in the written declarations, including the follow-up that I filed last Friday in response to Heidi's. So unless the other party has anything new to discuss, hopefully it was all made sense in the written declarations.
Okay, thank you. I did review everything that was filed. All right, Mr. Ball.
Thank you, Your Honor. So the father's asking for what would be a major modification. It currently has some supervised parenting time with some of the children, and limited parenting time. It's it's kind of a messy plan. It's one weekend he sees some of the children, and the next one weekend he sees the other children. And so my client would like to just change it to all the children go every other weekend. There is a non-professional supervisor who has been working with them, and I think she's agreeing to continue to work with them. But as far as the basis for this kind of modification to going from supervised parenting time and every other weekend to week on, week off, there hasn't been a change in circumstances on my client's part. She's been doing what she's supposed to have been doing and taking good care of the children. And so that's kind of her position. I think, there's still some concerns that she has, and some of the children are still reluctant to to participate in the parenting plan, and so we're working on that. But some of that still is resting with the father. So and this is just a temporary plan. We're hoping that we can, at a final resolution, we get a plan that's best suited for the children. So we'd ask that the court adopt her recommendation or her proposed parenting plan, which is every other weekend from Friday to Sunday.
Thank you, Mr. Wall.
Thank you.
All right, Ms. Turnbull, do you have any input?
Pardon me, I do. So one of the concerns with this case is that the children's ages, span from young to teenagers, and the needs of the children are different. And it's been reported that the father interacts with the older teenagers, the oldest boy, differently than he does with the younger children, and that he does a better job interacting with the younger children. And so that is originally why the visitation was separated, because mom and the younger kids felt more comfortable with dad being unsupervised with the younger kids, and the older two children didn't either want to interact with dad or felt like they needed to have this supervision. One of my concerns all along has been that there hasn't been any feedback from a professional supervisor about those interactions with the younger children. So the supervision has always been from a community supervisor, a lay supervisor. And so we haven't ever had any feedback to give us some direction about what those interactions are looking like. And when either for the younger children or for the older children. And so that is a concern of mine, is that dad has been very compliant in terms of following through with the domestic violence, getting any recommendations, following through with the autism evaluations that his counselor has made, following through with the counseling. He has definitely been making progress and being compliant with all of those recommendations. But in terms of what the interactions with the children are looking like, there hasn't been any feedback about how that progress is going. So that is one of my concerns in terms of making recommendations about moving forward.
And right now with the current parenting plan, the younger children, their visits are unsupervised, correct?
That is correct.
Right. And then as far as like the feedback that you ideally would have, where would that come from?
Just even a few supervised visits with a professional supervisor, just to give some input.
Okay. All right. Thank you. All right. And then just want to make sure with Mr. Ellis. Mr. Ellis, you represented in your pleadings that you anticipated graduating from the DV program. I think yesterday was the estimated time frame. Did that happen?
That did happen, and the completion letter will be going out today.
Okay. All right. Thanks.
And if I may, can I respond to any of those?
You may.
Comments? I very much respect the gal's recommendations, both previously and today, and I think that would be an absolute perfect idea to have a few professional paid visits with myself and the children. I do disagree with the other counsel's assessment that this is a major modification, because we've been operating under temporary plans this entire time, temporary plans that were contingent on the completion of those recommendations. And despite the court, and I already put this in my written declarations, despite the court not adopting any of those recommendations, I completed them all voluntarily. So this isn't a major modification. This is completion of what held me back from having my children in the first place. I know that there's, as Amy specified about Joseph, or the oldest boy, excuse me, but it's been 9 months since I last visited with him. So saying that what happened 9 months ago is still the case and we should hold him to it for eternity is, I don't believe, warranted. And finally, I am looking for this to be a final parenting plan. Heidi wants to move on, and the parenting plan and the division of assets are all that stands in our. So I would hope that we can come up with something that will not require modification every few weeks. And if we have to postpone it until those professional visits are done, I would certainly welcome that.
Okay, thank you. Just addressing that last piece first, as far as a request for a final parenting plan, unless the parties agree to a final parenting plan, then there would need to be a trial on the matter. So at this point, any order that I make regarding a parenting plan today will be temporary. The one concern that I have is just looking at kind of the history of the case, the life of the case. There was a temporary parenting plan issued on September 28th, and then there was another on December of last year, and now we're here again on a motion to change it. And I think that's where Mr. Ball is indicating that there's not adequate cause. So adequate cause, it's not completely set in stone that there needs to be adequate cause to change a temporary parenting plan. But the concern I have here is that the rapidity or the quickness in which we've had these evolving parenting plans. And I recognize life is certainly not static, and sometimes there are needs that need to be met through a quick succession of change of parenting plans. But that's the first issue that I raised, and that's the first issue that came to my mind: is there adequate cause, and is it needed? I think given the history of the case, I'm going to be a little more flexible and not require a specific finding of adequate cause to modify. So I'll take the case and look at it at this point. Historically, it sounds like well, what we know with Mr. Ellis is that in the past, his thinking has been a bit more black and white, and that tends to be a little bit easier when interacting with younger children. Younger children tend to be more deferring, and when a child gets to be a teenager, they tend to be less deferring, tend to be more nuanced, and kind of stand up and have their own views and thoughts. And so if things are black and white, and when a parent's mind and the child may be individuating or establishing themselves, they may have a difference of opinion there. And there's been some concerning events or unfortunate events that have occurred between dad and the oldest that really make it problematic for that relationship to just hop right back in. So I think as far as the temporary parenting plan, the suggestion from right now is the younger kids. There's a split. There's just the younger. I'll call them the younger kids, the younger 3, and then the older 2. That currently the youngers are from Saturday 4 to Sunday at 6, and the older kids is just a Thursday from 4 to 8 supervised. So I think we take into account the fact that Mr. Ellis has completed the domestic violence intervention program. He's continued his counseling. There's a pretty significant analysis and coming to a diagnosis related to the autism spectrum. So I think there's been some progress there, and yet that progress generally is going to be management of his person and his thought processes and the like. So there'll be no change as far as the primary custodial parent. Ms. Ellis will continue to be the primary custodial parent. As far as the younger kids, I'm going to change the visitation to alternating weekends, Friday at 5 p.m. to Sunday at 8 p.m. on the 1st, 3rd, and 5th weekends. I'm just going to note that here. And then as far as the older children, I'm going to set that on alternating Sundays separate. So that would be on the 2nd and the 4th weekends of each month. And that would be from 9 a.m. to 6 p.m. on Sunday. And the oldest boy, he can opt out. And I want the parties to undergo or at least start the process for reunification counseling between dad and the eldest son. And I'm doing that because I think Mr. Ellis has made a showing that he's willing to learn new things and maybe change and develop and improve, and his son may recognize that. And with the assistance of a counselor, that may bear some good positive relationship fruit. So that's the court's ruling related to that. We'll continue with the joint decision making. No change on that. Any questions from the parties?
Yes, Your Honor. I'm sorry, you said Friday 8 p.m. till Sunday.
Friday 5 p.m. until Sunday 8 p.m.
5 p.m. till Sunday 8 p.m. And I know you said first, third, fifth, second, and fourth. Being that months have varying numbers of weeks, that could end up meaning that some kids get 2 weekends in a row. I didn't know if that was confusing to the kids or not. We have typically just been operating on odd weeks of the year and even weeks of the year. Is that, what are your thoughts there?
Yep, Mr. Ball, any input on that?
I wasn't aware of that. I mean, I understand what he's saying about sometime there being consecutive weekends. So I think if my client has been in agreement in that with that in the past, we can continue to alternate the weekends like that. I don't know. I guess I did defer to her and allow her to make that decision. So maybe it makes it clear. So I'll communicate with them and see if that's what makes the most sense there as far as.
Okay. Yeah, I think Mr. Ellis makes a good point. That could lead to unexpected results. Yeah, the intent of the court is to have the children, the younger children be with father on one weekend, and then the next weekend the older children would be with dad. So the kind of that even on, if the parties want to continue on that process, that's the court's intent. So thanks for that clarification. Any other clarifications?
Yes. Earlier you spoke and said that I only saw the older children on Thursdays, but I do actually see them Thursdays and Sundays today, and you're reducing it to just the same hours that I already get them on Sunday only, every other weekend. And I'm worried because you also talked about the frequency of these temporary parenting plans coming. So what happens when we begin reunification counseling and those go well, or quantity, or however that goes? Is this going to be a year before I can come back and get the time back that's being taken away today?
No, I think the idea of reunification counseling is that if a counselor makes a recommendation, the court is generally positively responsive to that if that's it going in a good direction.
Okay, and then the other one is my black and white thinking at the beginning of this process a year and a half ago, or whenever the actual first court orders were entered, even caused problems with the children's visitation, and that is, do we force the children to go? And I have learned since that that does not benefit them at all. And so, as you have seen in the declaration, I haven't forced the older ones to go. And I would like clarification. You said only the oldest can opt out. What does that mean for my teenage girl who's going through a change in her life, and she loves to visit one day and doesn't want anything to do with me the next day, and then 2 weeks later it'll repeat? Is it being forced upon all but the oldest?
That's the court order. Okay, so we'll take a look at a date for presentation. The parties want to take a look at your calendars. That would be on June 5th at 9 a.m. How does that look, Mr. Ball? Looks like you're muted, Mr. Ball.
I can do June 5th. I'll prepare the order as well.
Great, thank you. Mr. Ellis, June 5?
I can do that, and I would just ask Mr. Ball, please keep with the current wording of even and odds, because I already have plans for the kids that I have on the odd weekend, young kids and old kids. They're booked out already.
All right.
Okay, I'll send that over to you, and you can get back to me about if there's necessary changes.
Thank you.
Okay, thanks to the parties. We'll see everybody on June 5th unless that's submitted and agreed, and I'll sign off on it prior to that.
Thank you.
And does it begin now or not until June 5th?
The intent of the court is that starts now, and then the parties will reduce it to writing, and it'll be signed on June 5.
Received. Thanks, Chair.
Okay. I have one matter that's on for presentation. It's the Heidi Ellis and John Ellis matter. 23-383-08 is the cause. Mr. Ball represents Miss Ellis. Is William Ball on the line?
Good morning, Your Honor.
All right, good morning, Mr. Ball. And is John Ellis on the line this morning? Mr. Ellis?
I am, Your Honor.
Okay, welcome to you. And I see Miss Turnbull is present, the guardian ad litem. Let me take a moment to grab the proposed orders. Yeah, first off, it looks like Mr. Ball prepared and submitted two proposed orders. One is a temporary family law order. The other is a parenting plan order. I'll ask if Mr. Ellis, if you received a copy of those documents.
I received a copy of those documents, but those were not what was on for presentation.
Okay, and Ms. Turnbull, did you receive a copy of those proposed orders?
Yes.
Okay. All right, let me follow up with Mr. Ellis. You had submitted some additional information after the hearing, and let me just pull that up here. So so this is from our hearing back on May 8th, where the court adopted pretty much in full the recommendations of the guardian ad litem. And the parenting plan, let's take a first look at that. I'll ask Mr. Ellis, in looking at the parenting plan, are there areas within that parenting plan order that you feel do not accurately reflect what the court had ordered back on May 8th?
Yes, sir. And first off, I would like to understand, because we pulled the transcripts, and although there was discussion about the guardian ad litem's recommendations, and I even proposed that I would be open to that, that wasn't part of your order. So I did take issue with some of those inclusions, but the parenting plan that the opposing counsel has proposed also falls under line. Over a year ago, I did just this exact same thing. I submitted a proposed parenting plan in response to a petitioner's hearing on a motion, and this court ruled that a proposed parenting plan would need its own motion and its own hearing, and it would not hear it. And that's exactly what he's done in this case. But in his proposal for presentation, he has completely substituted his own parenting plan instead of modifying the existing parenting plan with just the changes that you've ordered. Specifically, in section 3, our existing parenting plan has always left the reasons that a court must and reasons that a court may put limitations on a parent from reserved to claiming that there are 191 factors. They falsely listed in section 3 that the respondent must be limited due to 191 factors, claiming the respondent was found to have committed domestic violence per RCW 7105-010, and that I had no emotional ties to at least one of the children. Both of these are unfounded allegations that were reserved by the court during the initial petition for temporary family law and protection order over a year ago. The subsequent DV evaluation only recommended that if I did not complete a 9-month DV intervention treatment, that I would be likely to escalate to DV. The DV evaluator did not find that I had committed acts of DV and is willing to write a letter to the court clarifying this. Additionally, the DVIT program that was completed has prepared me to respond appropriately in these situations and further lowers the risk of reoffending, not raises it. My motion on the previous hearing in May asked for those reserve sections to be changed to not present, whereas the prepared orders have taken it from reserved to mandatory restrictions upon the hearing or upon the parent without any hearing or court order finding this to be true. Additionally, the lack of emotional ties was never in the original proposal by the petitioner, nor has it ever been any more than reserved in all orders. And the lack of ties is not from myself to the children, but from a child toward myself. I've never stopped loving, reaching out to, and caring for the children, even though some are rejecting me in this process, and this section too should be left reserved or not present. You did not order on that, and he has made the change. Additionally, he has completely changed out section 14, which is the other section. Our existing parenting plan had some of that verbiage proposed initially, and the petitioner abused it. She scheduled the children to have extracurricular activities that interfered with the parenting time by father, and those were never adopted into the parenting plan. He's again proposing that this be allowed and that it would take precedence over the parenting time. I see nothing in your order that related to section 14, and so it should be left exactly as it was in the existing order. Similarly, he's put in a holiday schedule, which he's asked me if I would please agree to. I cannot agree to a holiday schedule of 3 changes a year when I don't have unsupervised visits with all of my children, because as it is right now, I have not been able to take any of my children on a vacation for 2 years, and even my little ones, the longest I can go is 2 days. My proposal, which you didn't order, but my proposal asked that we have a 2-week summer vacation as the only change to the weekly visits. And then, of course, as you read in my subsequent declaration, I feel that the court was trying to help in giving the children back additional time with the respondent, but inadvertently has done the opposite by taking the preschool age children from seeing father every what was a few days initially to 7 days. They realized that was a mistake. They reeled it back to every like 4th or 5th day. Now it's all the way out to 14 days. 14 days between a preschool set of preschool age children seeing either one of the parents. And I don't believe that that's in the best interest of the children, but it was your ruling. Regardless, I would ask that the court not do what unusually happened at the last hearing, and that is allow opposing counsel to prepare the presentation on the other party's motion.
Thank you, Mr. Ellison. Let me ask you just a brief follow-up question on that last point. Did you submit any proposed orders?
I submitted in the previous hearing proposed orders, a proposal and an order for signature. When you made an order that didn't adopt all of those, Mr. Ball quickly piped up and said he'd prepare the presentation, to which this court agreed, denying me the ability to prepare my own presentation. And we wouldn't be having this conversation because I follow orders. So it would be the old parenting plan struck with the pieces you ordered and inserted the parts that you had ordered to be changed.
And you're referencing it looks like an April 19th submission of your proposed parenting plan, correct?
Yes, sounds reasonable, yes.
Okay. So in your proposed parenting plan from April 19th, under section 14, comparing those two, the current proposed by Mr. Ball and yours, is there some overlap, or is there some areas in which they are similar, or are they starkly?
There probably is overlap. I did not read them letter for letter. I just noticed that his was very boilerplate. And the last one caught my attention, which is the sports and extracurricular activities, which supersedes parenting time. And that's exactly what Heidi has used in the past and been told that is not to happen, even though it's still happening.
Okay. All right. Thank you, Mr. Ellis. Mr. Ball.
Thank you, Your Honor. So under section 3, the 191 factors, I saw that was reserved on the temporary orders, the previous temporary parenting plans, and the court didn't specifically order that. So I included that. I was just going to run that by the court today because there is supervised parenting time and there is reunification counseling. So that's why I included that. And then there is another issue with section 4 that Mr. Ellis didn't mention. and we talked about this, it has to do with the professional supervision that's under supervised contact. I don't think that there was some discussion at the hearing whether or not the parties agreed to that, but it wasn't specifically ordered by the court, and Mr. Ellis is not agreeing to that provision. And well, that would need to be, we're just addressing that to the court. You know, it's completely discretionary on Mr. Ellis's part. He brings up the fact that it's expensive and and he already has a high maintenance order in this case, and well, he also feels that it's going to be used to further, you know, curtail or affect his parenting time or try to reduce his parenting time in the future. But that's not really the spirit of it. But so that's the other section Mr. Ellis didn't mention. On the holiday schedule, we were trying to get an agreement on the holiday schedule. Apparently, Mr. Ellis doesn't agree to that. What he brings up, the good point, is that he can't have us, you know, the older children would need to be supervised or something like that. And there's not a supervisor available on holidays because they're using a friend. And so that I would say, I guess he doesn't agree to that. So that I guess should be stricken. Otherwise, I would say that it would apply to the younger children, and the older children could opt out. It would be, but that wasn't ordered by the court. And also under section 12, this is agreed change. I don't think Mr. Ellis touched on this, but transportation arrangements under other location. It should say the location of the father's parenting time, striking out the word supervised, because I guess sometimes he has parenting time, or the location where he's visiting with it, having parenting time with the children, is not at his home. As far as the other sections, I just this is what I use in my office. I didn't mean to exclude anything or include anything that had, most of the time, these times it's just what the court will order. Other factors, I don't have the information about what Mr. Ellis is talking about scheduling extracurricular activities. But but I think what makes sense if the court's going to entertain this is that it should be extracurricular activities that are through the school, through the children's school, as opposed to I don't know, like piano lessons or dance lessons or something like that. So those would be the limiting things I would, just from my perspective. But I think I was looking through his real quick, and I don't have an objection to those necessarily. I don't know which. I guess if he wanted to pull his page or something like that and put it in there of his
on his section 14.
Yeah, I don't know so sorry to screw that up, but so that's what I have on I think those are all the objections that Mr. Ellis brought to my attention.
Your Honor.
So one moment, just a follow-up question for Mr. Ball. On Mr. Ellis's section 14 of his May or April 19th, you're comfortable just pulling those 1 through 16 and placing those into the section 14 of your proposed? Is that what did I hear you correctly?
Yeah, I mean, I don't really see I don't know where they came from, but so I looked at them and they seem okay. I don't know if there's an issue with the extracurricular activities or not. That's what I'm saying.
Okay. Mr. Ellis, would you be comfortable if we took your section 14 and placed it in the proposed order of Mr. Ball?
That would certainly be a start. I have no reason to change section 14. Its origination was the petitioner's original attorney, Tanya Green. She's the one that created that verbiage, not I. It's been copied from order to order.
Okay.
And back to the section 4 and me not agreeing to it, I did agree in discussion at our hearing. I would love for the court to order that I have a fixed number, not an open-ended number, which is in, I believe is how it's worded in Mr. Ball's proposal. I would love to have the court order, say, I don't know, 4, whatever you think's appropriate. Amy's on the line. She can help determine what that is. I had a wonderful conversation with Beth Bellows after the last hearing. She is the proposed supervisor, professional supervisor. If I knew that there was an end to it and the end result would be the removal, or I would hate to say continuance, but the removal of the non-professional supervision for the 2 oldest, I absolutely would entertain that, because I want anything that will get me back time with my kids that the court won't view as repeated hearings or changes and modifications. As long as it's court ordered to come back up, which I feel like all the others were, then yes, please, let's do it any way that we can to show that this is in the best interest of the children.
All right. Thank you, Mr. Ellis. All right. So starting off with the 191 factors in section 3, there is included a history of domestic violence and also a lack of emotional ties that specifically says that there's few or no emotional ties with the child listed in paragraph 2 or section 2. So Mr. Ellis points out that he's completed the domestic violence course successfully. He points out to the course curator or the course presenter indicating that he doesn't have domestic violence. I think the key difference here is that there's a history of domestic violence, and domestic violence is defined rather broadly under that 7.105. So I'm going to include that in there as a history. As far as a lack of emotional ties, I think that's, Mr. Ellis points out that it's unidirectional in that he has lots of love and concern for his children, and that there's maybe not a reciprocity returning towards him. I think the fact that there's the supervised visitation that the court did order, and there's reunification counseling order, that highlights the fact that there are some strained emotional ties. So I'm going to leave that section or that portion in the proposed order. Under section number 4, the limitations as far as the supervised contact, Mr. Ellis is concerned related to an end time for that provision. And he wants to have a set number. Determining when a child is or a parent or the combination of the two is ready to move on from a certain set of conditions is difficult at best to predict. Yeah, human nature is difficult to gauge, and where a person is and how quickly they'll get to that stage. I understand that the need and the want to have a set date for it to end. I'm certainly not opposed to a review to address that issue, but I think it'd be not wise to set a hard and fast date as like this is when this provision is going to end. Certainly a review date could be set or could be noted up for review. I'm not averse to that. So so that number 4, I'm gonna leave that in as presented. Then looking at section 14, I'm fine with the wholesale replacement of the proposals, the paragraphs proposed by Mr. Ball, and replace them with the proposals propounded by Mr. Ellis in the April 19th order, for his proposed order. Under the holiday schedule, there's a lot of information in parenting plans that in a hearing isn't necessarily addressed bit by bit. If we did, we would have 7-hour dockets. So there's some kind of a shorthand that is generally used. And so that since the court did not order the holiday schedule, I'm striking the entire thing, and the parties will be on their own to try to figure that out. Under section 12, I did make that correction, removing the word supervised under lines between 6 and 7. So the exchange location would be at the father's parenting time. So related to that, I'll ask Mr. Ball if you would be in a position to amend your proposed order to include the section 14, including Mr. Ellis's proposals therein instead of yours, striking the word supervised on page 5 and striking the holiday schedules, and then submit that to the court and with a CC to Ms. Turnbull and to Mr. Ellis.
Except looking at section 14, it does include the a provision about reunification counseling. And so I wanted the judge to peek at that and see if that was sufficient enough language there. But I would keep that in there and then strike the rest of it, include the previous or the one from father's proposed orders.
I think that's fine, Mr. Ellis. Any comment on that?
I'm sorry, reunification counsel is in section 14, your section 14?
Under
Oh,
Mr.
at the
Ball's.
very top?
Yep, at the very top, right.
I thought it was also under section 4.
I
Maybe
think
not.
it's a little bit different if it wasn't for, because I didn't remember Ms. Brandhorst's name being included there.
So that's fine to put that down in section 14 as a header to whatever we're substituting back in, the old stuff.
So we'd keep reunification counseling, keep that paragraph in, and then just take wholesale your proposals from your 14 and include them below that.
And Your Honor, when you said that you're keeping section 4, opposing counsel had agreed via email to remove the unsupervised children, because the way he wrote it, section 4 states that I will now go from unsupervised with my children to all supervised with my children.
I thought it says the parenting time regarding Joseph and Carly.
So in the parenting, the parties will use a non-professional supervisor, agreed third party, but then the very next sentence says, father will use a professional supervisor, Beth Fellows, for his parenting time with all children.
Well, maybe the language says father may use a professional supervisor. Maybe Mr. Ellis's copy. I think that was the original language, but we changed that.
Well, the only one that I have by email says will.
Yeah, so yeah, the parenting plan that I'm looking at says supervised contact, parenting time with Joseph and Carly shall be supervised. The parties will use a non-professional supervisor and agreed third party. Father may use a professional supervisor for his parenting time with all the children to be able to provide feedback about parenting, interaction, relationship from that supervisor.
Okay, so Your Honor, that's hard to follow when you read it. I'm now understanding that you are marking up a copy of a document that I have no copy of. So I don't know exactly what we've.
Well, I'm looking at the same document that was provided from Mr. Ball, so you should have a copy of that.
Yeah, but that's not the one he sent me.
So what does your copy read?
My copy is, let's see what it's dated here. Mine doesn't have a date on it. It's 9 of 8 pages. And in that section, it says, father will use a non-professional supervisor, agreed third party. Father will also use a professional supervisor, Beth Fellows, for his parenting time with all children to be able to provide feedback about his parenting.
All right, so it looks like it may be a different version. So what we need to do is make sure that it reads that the parties are going to use a non-professional supervisor and then uses the permissive language of using a professional supervisor, basically for feedback. So we're going to need the order itself needs to be revised with the replacement of section 14 with that reunification included. So we're going to have to come back and look at this with fresh eyes. So let's come back next week and just parties can exchange those copies, and then we'll be back here and we can take it first on the docket and get it done quickly so as to not take additional time from your schedules.
And did you I know you talked about a review from say Beth Fellows, did you actually modify section 4 to include that, or how is it?
Yeah, good question. I didn't set a specific date. I was certainly open to that possibility, and I was also open to the possibility of having one of the parties, yourself included, noting it up with notice to the other side to review that specific issue. So it was kind of flexible in my approach.
My fear is that last hearing, I felt like it was held against me as the number of frequent changes to parenting plan. Is that going to be held against me?
So we're talking about a potential review. So let's kind of focus our attention on that. So if you want to propose a date for a review, I'd be happy to include that within the order.
Okay, we'll bring that back next week then. And I would also like you to clarify once again, in the last hearing, I asked for clarification. When did this take effect? And you said immediately. I've already ordered it. And we have a case where I have an email from Heidi that refuses to begin the reunification counseling until there is a signed court order to do so. How do we tell the opposing party that it was already ordered back on May 8th or whatever it was, and that it is not voluntary, it must be followed?
Mr. Ball?
Your Honor, my client reached out to the counselor the day of the hearing, at our last hearing, and she just conveyed the message to Mr. Ellis that the supervisor wanted the order. So she's not refusing to engage in reunification counseling. She hasn't done that, but that's what she told Mr. Ellis, is that
Okay.
when you sign order.
All right, thanks. So the order is in effect. It is in effect as of May 8th. It sounds like the counselor may have some other requirements. So all parties are expected to follow the court's oral order, and then we'll be back next week to finalize the order with the revisions. I think we spent more than adequate time on the issues today. Ms. Turnbull, do you have any comments?
Not at this time. Thank you.
Okay, we'll come back next week, assuming all parties are available. Mr. Ellis, Mr. Ball, both available next week on the 12th.
Yes, Your Honor.
Yeah, self-available. And thank you for your flexibility. I know it was a lot of time.
Okay, great. We'll see everybody then. Thanks.
Thank you.
Heidi Ellis and John Ellis.
John's present.
Guardian ad litem, Amy Turnbull.
And do we have Heidi Ellis?
Um,
Good morning, Your Honor. I'm William Ball for Heidi Ellis.
All right.
Your
Any objection to the proposed orders?
Sorry, I'm assuming you're asking myself.
Your Honor, there's a section there where the court needs to fill in a date and time for a review hearing. I think that's one of the reasons why we came back in today, is to include that language about a review hearing.
And Mr. Ellis filed his objections in writing.
And that's under section 4, Your Honor, if you have the order in front of you. On line 17.
Okay, so Mr. Ellis, is there any part of this proposed order that you think doesn't accurately reflect what the ruling was?
Yes, because this is not what was ruled on. What was ruled on was my motion. We've already gone over this in the last hearing, and the judge ignored the objection, even though, as I put in my, I'm not gonna repeat it. It's in my declaration there, everything in that first paragraph of what has occurred here. What you are looking at today to sign is not what was ordered at the May 15th hearing, but this court has allowed it, and I cannot agree to it.
Okay, well, unfortunately, it sounds like Judge Evans is going to have to make that call in. So when can we set this for him?
Judge Evans has already heard my objection and ignored it. So I don't know what going to another hearing date will do, sir.
Well, what you're telling me is that you think that these orders in some respect don't reflect what Judge Evans ruled.
He changed his ruling at the next hearing. He agreed with opposing counsel.
So Mr. Ellis, let me ask this again. Does this proposed order accurately reflect what Judge Evans ruled?
And then some, yes, Your Honor.
Okay, so can I sign this order today? I understand that you disagree with Judge Evans' ruling. Can I sign this order today, or do we need to put it over again?
If you sign that order today, I am unable to comply.
All right, we'll put this in front of Judge Evans on July 3rd, 9 o'clock. And we'll hang on to your orders, counsel.
Okay, thank you, Your Honor.
Thank you, sir.
All right, next I have Heidi Ellis and John Ellis, cause number 23383-08. I'll ask if Heidi Ellis is on the line.
Yeah.
All right, and you're being represented by Mr. Ball, I believe.
Yes.
Okay, Mr. Ball is still online, thank you. And then is John Ellis on the line today?
Yes, sir.
All right, welcome to you, Mr. Ellis. We're on today for presentation. I've read the objections filed by Mr. Ellis, and he raises some good points related to our local rule indicates that all proposed orders will be prepared and filed by the moving party, and he expressed concern about that the court had asked Mr. Ball to prepare that. I think his request is fair. So what I'd like to do is, if Mr. Ellis wants to prepare a proposed order of what the court's decision was from May 15th, I would entertain that. He could send a copy to Mr. Ball, and then we would have both proposed orders before the court. I think that seems reasonable and it seems proper. And so that would, and I'll just ask Mr. Ellis if you have any questions about that and what timeframes you would need to do that.
I can certainly prepare the order as you ordered it. It would not, of course, include some of the extras that the opposing party put in there. I would ask for the typical 2 weeks or 3 weeks, whatever it is. It won't take me that long, but I still have concerns, as you read in those objections, about how I'm going to meet what the court ordered based on the reduction in time and the supervisor's schedules.
Noted. July 17th would be 2 weeks. I'll check with both parties to see if that would be workable.
July 17th is fine by me.
All right, thank you, Mr. Ellis. Mr. Ball?
Yeah, I'm available that day. I guess my only concern is, now this is, I think, the third hearing we've had on the entry of orders. So that's what my concern now. We've spent a lot of time on this, and okay, if that's fine, that's what you want to do.
Yeah, understood. I appreciate the concern related to the timeliness of the entry of the order. I think given those proposed, the objections to the proposed, I think that's a fair consideration. And so we'll come back on July 17th. Mr. Ellis will have served a copy of his proposed order from the May 15th hearing to Mr. Ball, and then we will be back on the 17th to flesh the respective orders out and enter an order.
I did have a point of clarification that might help us along, and then that I think we didn't describe who's going to pay for the reunification counseling or how that's going to be paid. So that's one thing that we're going to have to decide. So anyway, if you want to make a ruling on that, that might further us along.
I think as far as we're here on presentation from a May 15th hearing. I don't think the court had indicated of what the payment parameters are related to that.
Yeah.
So if we address it today, I'm not exactly sure what information the parties would be using as a foundation for the requests. Mr. Ball, do you have any idea on that?
Well, I guess it would either be, the options are that it's going to be shared either 50-50, it's going to be shared pro rata, or, I think oftentimes it's the parent that's going through the counseling pays the entire expense. Pro rata based on the child support worksheets.
Okay. All right, Mr. Ellis, do you have any input whether the court makes a decision on that today or waits until the 17th to make a decision on that?
Well, honestly, Your Honor, I realize that this is supposed to be presentations, not making a new order, but I agree that what was ordered is not achievable even as it was ordered. And part of it is around those financials. The court's family support order, combined with the other orders that the court has made along the way and additional responsibilities they left with me, now totals 125% of my income. And that is not counting for any of my personal life support needs. So out of those three options, I would go with the prorated, which is about roughly 35% mine and the rest Heidi's. But I still don't know where I'm going to come up with it.
Okay, all right, thank you. I'll set it at a 60-40 split, 60% Mr. Ellis, 40% Ms. Ellis for the reunification counseling, recognizing that there's concerns expressed by Mr. Ellis about his ability to meet all the needs that are imposed upon him. All right, we'll be back on the 17th of July.
Does that also apply to the professional supervision that was never ordered by the court?
So this is the difficulty that we encountered when we kind of opened things up. We're here for presentation. I recognize that. So both parties indicated it'd be helpful for the reunification counseling cost to be addressed. If you feel that would aid in the presentation docket or hearing on the 17th, I can address it, recognizing I haven't spent much time thinking about it.
Then I would like you to get time to think about it. Can we do that?
Oh, could you repeat that again?
Then I would like you to have time to think about it. Can we just present it exactly as the May 15th order was, and then we figure it out there?
Mr. Ball?
That's fine. Thank you.
Yeah, let's do that. Let's address it on the 17th and we can go from there.
Okay, and that's for the reunification as well, or just for the professional?
So for the costs of the reunification counseling, I've addressed that today.
Okay.
As far as the other, that would be on the 17th.
Okay. All right. Thank you, sir.
Great. All right. We'll see everybody then. Thank you.
Okay. Thank you, Your Honor.
Let's go to the John and Heidi Ellis matter. That's cause number 23383-08. Mr. Ellis is present. Come on up, Mr. Ellis. And I'll ask if Mr. Ball, are you on the line, Mr. Ball?
Morning, Your Honor.
All right. Good morning, Mr. Ball. All right. we're here today for presentation of order. I've reviewed the proposed parenting plan submitted by Mr. Ellis, and I reviewed the objections by Mr. Ball. So in essence, what I see here is that the parenting plan submitted by Mr. Ellis would, Mr. Ball is indicating that he's okay with that, but with a few objections. Is that accurate, Mr. Ball?
Yes, Your Honor.
Okay. So having reviewed your parenting plan, Mr. Ellis, there was the petitioner, Ms. Ellis's objections. Did you receive a copy of her objections?
I did. And I also will point out that with those objections, opposing counsel included a July 3rd dated parenting plan, which is not what I filed with the court or had him served with. He has my signature on it. He has it marked as being presented by me. That is not the one that was presented by me.
Okay, I have the one that you submitted that has your signature on it. So
Dated July 8th.
Yes.
Thank you.
Yep, that's the one.
Yes, so I reviewed their objections.
Okay.
And we've already had the section 3B objection here.
Right.
This court ruled on 3B that it was unidirectional from the child to the parent, not a problem of the parent. And in 4 and 14, I've repeatedly pointed out to the court that having a named provider limits my ability to find one that's within my financial means, that works for the child and myself. And both of those named providers have already informed us that they are not available during the court-ordered visitation schedule. And on June 5th, via email, opposing counsel has made it clear that Heidi will not agree to any other time that is not so ordered by the court. So
Okay.
it needs to be clear that there is additional time that fits with the counselor to do those counseling sessions. And I put that in my June 8th presentation and declaration.
And that's, tell me where that is in which paragraph that's where you indicated that additional time for the supervised visitation to occur.
So in my declaration dated
Well,
July.
not necessarily your declaration, but the proposed parenting plan.
So the proposed parenting plan, it's in section 4.
Okay.
And prior to the May 15th hearing, I had 2 evening visits every week with my children. And on the May 15th hearing, you took those away.
Right.
I'm asking for those to be restored, and it is listed in section 4 as every Monday, 4 to 8 p.m. and every other Friday, 4 to Sunday, 8 p.m. So the every Monday, 4 to 8 p.m. is a restoration of the pre-May 15th weekly visits. And then similarly, the next section I used to have every Thursday with the older children, I have put it into section 4 as every other Friday, 4 to 8. I know that's less than what I had before, but that's what I can do.
Mr. Ball, with regard to, I'm working off of Mr. Ellis's July 8th proposed parenting plan. Do you have a copy of that? Can't tell if he's frozen. Looks like.
Oh, I'm not frozen. I'm looking on to make sure I have. I thought it was the same thing. I don't know. The one that I had. Let's see. Was, oh, okay. That was not the one that he submitted. I'm not sure what the difference is. Let me just look then.
Yeah, I think
that is the only difference.
I think Mr. Ellis indicated that the difference is that for the 3 younger children, he added every Monday 4 to 8, and the 2 older children, he added every other Friday from 4 to 8.
Oh, okay. I see what happened then. Yeah, no. Okay, yeah, my client doesn't agree to that.
Okay. So with regard to Mr. Ellis's concern that the providers, the professional supervisors don't work on weekends, and there's a provision that would allow Mr. Ellis to use a professional supervisor to provide feedback. Do you have any thoughts on that?
Well, that was my understanding, is that it would be supplemental to his regular parenting time. That's the way I thought. That's the way it had been written up, and so it would be. So I guess you could, if you want to clarify that, or that should be clarified, that it would be in addition to his other parenting time. I mean, I didn't mean to make it so his regular non-supervised parenting time would turn into supervised parenting time. That wasn't the intent at all. The intent is for him to have his parenting reviewed, so that and then to set a review date if he wanted to, so the court could hear from the supervisor.
Okay. All right. So this is kind of what I was thinking, is that Mr. Ellis indicates that, his concern is that the court has reduced his time, and that there's a 12-day period that goes between certain visits with certain children. And so his concern is that he wants that restored, so at least there's some greater contact. And that's also tied to the potential for having that supervised visitation during those periods is kind of my sense. So in looking at the And looking at the proposed order that Mr. Ellis has submitted, it adds for the younger children every Monday from 4 to 8, in addition to the alternating Fridays to Sunday, which are unsupervised. And then for the older children, it would be that every other Friday from 4 to 8, in addition to the Sunday, and still with the older boys opportunity to opt out of those times. I'm fine with that, so I'm going to go ahead and include that because those would be opportunities to, one, lessen the amount of time in between, and it would also allow for that supervised visits to occur, those supervised visits to occur. The next portion, so I'll leave those in as proposed by Mr. Ellis. The next portion I wanted to address was the proposed supervised visitation language that Mr. Ball included in his proposed language that indicates that it be a named professional supervisor, Ms. Fellows. Mr. Ellis, are you okay with that, or you just want it to be maybe blank and say a professional supervisor?
I think just strike the name,
Okay.
leave those three places where it names Beth Fellows. I mean, I like Beth Fellows and all, but I got to get on her schedule. So take her name off of there, leave it as professional supervisor, and the professional supervisor's office, where it lists down below that the first visit shall be at Beth Fellows' office. And then at Beth Fellows' recommendation, you change to the supervisor's recommendation.
Okay, so in general, you're okay with that language, but just the proposed language by Mr. Ball, but striking Ms. Fellows in every instance and just leaving it be at the professional supervisor's office, if you will.
Yeah, I recognize that it's an entirely optional section, but also that this court didn't follow the gal's recommendation and has now placed that additional roadblock. So I'll take advantage of it.
Okay. Mr. Ball, any concerns if we strike Ms. Fellows' name from the proposed language?
I just got minor concerns. I think that's what we had kind of agreed to use her, but if he doesn't want to use her, if he wants to find a different one, I guess that's fine. I guess. I mean, that schedule that I wrote in there is one that Ms. Fellows had recommended. That's what the amount of time she would need to have to be able to do a review, I think is. So that's fine if he has another professional supervisor. I don't.
Okay. And then Mr. Ellis, from your vantage point, that proposed language, that kind of sets out some timeframes for a period of 2 months, number of visits, and a period of 1 month as a number of visits. Do you have any concerns with that language? And I'm looking at specifically.
I don't think I did. Let me just look.
Yeah. It says the schedule for the professional supervisor would be for at least 2 months. Father will have 1 weekly visit of 2 hours or more, followed by 1 month of 2 visits per week, of visits of at least 2 hours in duration.
Yes, that was all fine.
Okay.
And do understand, I'm not against Beth Fellows. I just got to find one I can afford.
No, there's some flexibility by just saying professional supervisor.
I would ask that the court continue in Mr. Ball's piece there where it's got some blanks. We had talked about the frequency that we were back here. And I would like to have some sort of pre-approval that we're going to be back here on a particular date for review.
Do you have a proposed date for that review? Because with the kind of the schedule that's listed above, it talks about roughly a 3 month, looks like a 3 month period, because it says for 2 months and then for 1 month. So 3 months from today would be what, October? Let's see, July, August,
Assuming
September,
I can
October.
find one and get started right away. So let's, would it be okay to say, what's 4 months?
I mean, the week.
Yeah, 4 months. Let's see, let's look at the calendar here. So we have July, August.
That's not 12 days.
September, October, November. So November would be 4 months because November is the 11th month. We're in the 7th month. So we could look at a Wednesday in November to review it. The 20th is the
Sunday.
there's a potential I'm not going to be there during that time frame. So we could either look at the 13th, I'm absent also. So we could either look at a review date of November 6th or the 27th of November. Those would be two optional dates, or potentially December 4.
Let's do November 27th, please.
Mr. Ball, November 27, how does that look?
That should be okay.
Okay, so we'll set that date therein, which will be November 27th, 2024 at 9 a.m. for the review. And so let me just ask, Mr. Ellis, do you have your proposed, most recent, the July 8th proposed order? Do you have that in Word format that you
I
could
can
forward?
get it to you in Word format. I did not.
Okay.
Yeah, I printed it off for the court here, but
Yeah, that would be helpful, because what I can do, if Mr. Ball, you could send me your objections document in Word format and then send a copy to Mr. Ellis, then I would have that and I could just copy and paste with the few adjustments we've talked about here today. And then Mr. Ellis, if you send me your proposed July 8th parenting plan, then I can take that language, fit it into what you've prepared, and then just make those adjustments we've made today.
you had also intended to address the cost distribution on this section.
Sure. Yeah, we're not done reviewing. There's a few things we still need to review, but I just want to make sure. Do you have Mr. Ball's email address?
I do. How would I email you?
Evans M. So last name Evans, first initial M as in Michael, at cowlitz.wa.gov. So cowlitz.wa.wa.gov.
There was no period between the Evans and the M, correct?
Correct. Correct. And Mr. Ball, do you have Mr. Ellis's email address?
Yes, I do.
Okay, great. If at all possible, if you could get that to me before close of business today.
So you want me to send the objection language to you in Word format?
Please.
All right.
Yeah, be great. Okay, great. Then the last portion of that proposed language is related to cost of the supervision. Mr. Ellis, did you want to address that?
Yeah, I would like it specifically identified. The opposing party has made it clear that she will not do anything that's not ordered by the court. So ambiguity is not good. And this says any cost of supervision must be paid by John Ellis, which is definitely not ambiguous, but it also doesn't follow the 38% John Ellis, 62% Heidi Ellis proportional share that we have in our family support order.
So your proposal is to, rather than you pull the full freight or pay the full freight, there would be the proportional share as based on child support percentages.
That would be my request.
Okay. Mr. Ball.
So Mr. Ellis should pay the cost of the supervision. He's the one that is benefiting from it. I've heard other attorneys say that, it's his fault that he's having supervision. I don't agree with the fault-based language of it, but in some sense, it's for his benefit. My client, I think, I don't think she's working right now. She's attending school. She's taking care of the children full time. So I know both parties are financially strapped here. But I'd request, I think normally it's the person who has the supervised parenting time has to pay for it. And since it's also discretionary and asks that it's not even that much of a burden on him to pay for it. So.
And I object that it's for my benefit. This is for the children's benefit. It was recommended by the guardian ad litem not to have paid supervision. That's what we've been doing. And now the paid supervision has been offered as a way to remove the supervision altogether, which was best for the children. It's not just for my benefit.
Thanks to both. Let me ask when the court made its decision on the cost of the optional supervised visitation, did the court make a ruling of who would bear those costs on that date back in May?
No.
The court had to look at the court notes. I don't recall. This is our fourth or fifth hearing on this, so I don't recall.
Bit of it. I'm just looking back.
I'm very clear that no order was made on the distribution of payment until the very last hearing when you assign 60% of the reunification counseling to me. And I specifically asked about the professional supervisor, and you said you wanted time to think about it, and that would be today.
Thank you. Mr. Ball, any input on that procedural or the procedural history?
I don't think, I think that we were going to address it today. I tried to address it last court hearing, but that was opening too much of a can of worms. So I think it was reserved for today, so it wasn't ordered.
Mr. Ellis's rendition is accurate. So two different philosophical views of the parenting plan, the supervised, the cost of the supervisor. One theory is that it's benefiting Mr. Ellis. It's a means by which he can manifest his parenting and have that report reviewed by the court to adjust the parenting plan. The other school of thought is that that supervised visits is for the benefit, really kind of it's kind of a holistic view in that the child is benefited, the parent is benefited, and when the child and the parent are benefited, then the whole family is benefited. Here in large measure, that supervised visitation, kind of at its root, its basic purpose is to allow for Mr. Ellis to kind of push back or paint a different picture than what maybe the court has decided. So that comes, obviously that's a benefit, I think, for any parent that wants to have more time with their children. That's something that they're interested in, that's a benefit that comes to them. And obviously with that benefit, that has the dual purpose of, with more time and the reunification counseling, and if all that works out, then the family is more cohesive and there's tighter union. So kind of both camps are fulfilled by the costs of the supervised visits. I think it weighs more heavily in that the benefit is maybe greater to the first camp of Mr. Ellis. And so I'm going to require 80% for Mr. Ellis and 20% for Ms. Ellis. So that language here that's proposed by Mr. Ball, maybe Mr. Ball, when you make that your edits, and Mr. Ellis, you're free to do this in your July 8th submission if you want to amend it to reflect that the costs will be split 80% Mr. and 20% Ms. Any other items? Then I guess the next item is the use of Barbara Brandhorst as the reunification counselor. Any concerns with that language, Mr. Ellis?
Yeah, same as the previous one. I would just like to strike the quoted part that says the parties shall use Barbara Brandhorst as the reunification counselor, father, and Joseph Ellis. Other than that,
okay.
Father will comply with the counselor's requirements. The counselor may suggest a parenting schedule for Joseph Ellis. It's fine.
Okay.
And I did already have the reunification counseling included in section 14 of the one that I presented. So
Right. Okay. Mr. Ball.
I'm just reviewing the language that I think we got. Oh, okay. I don't know. I don't recall why we had Barbara Brandhorst. I know that's who they used before. Sometimes it's helpful to name a person in there, and so we know it's sometimes hard to find a reunification counselor. But I guess if there's another one that he wants to propose that does that, I don't really have an objection to it.
Okay. Yeah,
who's ever going to be successful, I think, is probably who should do it.
Sure. Yeah, I'll strike the language, the name of the specific counselor, Barbara Brandhorst. I'll strike that, and in its place, it should read the party shall use a professional reunification counselor. or credentialed or licensed or something along those lines.
Okay.
So I think that addressed all the issues in the objections. Anything that's been left undone, Mr. Ball?
Your Honor, I did want to, and I'm sorry I had to revisit this, but I feel that, you know, the change in the regular parenting plan, I wanted to address that because that is what, you know, what the way we had proposed it is what the court order. And so to shift it there, I just want to bring my client's concern to the court again, is that, you know, she feels that the current schedule is working, that that it's not in the children's best interest to add that extra time on the Monday there because it kind of interferes with their schedule. There's already some reluctance that she's having to deal with, and then children go into the parenting time, and so it kind of interferes with, you know, the schedule, like the bedtime routine that she had set up. So so she does have some concerns that, you know, she voiced to me that we didn't have a chance to bring up. So sorry to bring that up again, but I wanted to raise that.
No, that's important to hear your client's concern. Thank you, Mr. Ellis.
No, I thought we'd already covered it, that this was part of their regular schedule already prior to May 15th. And the children have expressed problems with the new schedule to me because they don't see me for nearly 2 weeks. It's 12 days between when they see me and when they see me again. They leave on a Sunday and they don't come back till Friday, 2 weeks later. It used to be that we got to go do fun stuff on Monday nights, and we can't do that anymore because these are not available on weekends. So I don't see this as adding time for the kids. I see it as restoration of time that was lost in their previous schedule.
Okay. All right. Thank you.
Can we make it an every other Monday or something like that? So we're concerned about the, you know, the length of time in between. And plus it would be a Monday, it would be a Sunday, and then the next Monday, you know, on his every other weekend. So, you know what I mean?
Yeah, I appreciate
Another
the
transition.
Yeah, I appreciate the perspective of both parties. Yeah, there's no perfect schedule when two parties have separated. So I'm going to leave the language that included the Monday for the younger kids and the alternating Fridays for the older kids. All right, so I'll look forward to the emails from both parties, and make sure you see when you send it to me. Make sure you're CCing the other party.
And will
right.
those? Sorry.
So I think that concludes our the order on the presentation. Mr. Bald, anything else?
No, thank you.
Mr. Ellis?
Yeah, the reunification counselor has indicated that they need a signed court order in order to begin counseling. Is this something where we got to come back again in a week, or are you going to do it ex parte and email it back, or how's that work?
Yeah, what I'll do once I receive the proposed different documents from each party, I'll merge them into one using Mr. Ellis's proposed parenting plan as the base, and I should have that signed today, and it'll be filed so the parties. And if you'd like, I could email a copy to both parties.
I would appreciate that.
I'll get myself a note, and then I'll do that. All right, that'll conclude things. Thanks.
Okay, thank you, Your Honor.
Thank you. Right, next.
Good morning, Your Honor. This is Brandy Jeffers. I'm coming in on number 2, the Kanata and Thomas matter. It is going to be a request